Yes, Mr. Rajchandra.
Item number 38, Ashika. In fact, this matter has become infractuous, so I am not pressing it.
38.
Item 38.
Mr. RKT, the learned counsel appearing on behalf of the petition admits that he does not want to press the petition in view of the fact that the petition has become infractuous, taking into account the same in the petitions that's dismissed.
Item number 25 of
Use that microphone. Yes, better.
my lordship, I beg to mention item number 25 of today's listing.
25.
Only this matter may be passed over for a week.
Why?
My senior is out of station, my lordship. This is regarding the wrong fixation of salary, my lordship.
Then
Senior is out of station, file is not.
it's to the learned counsel for the petitioner matters that adjourn for 4 weeks.
I leave. May it please your lordship. Lordship, I beg to mention item number 22 of the daily list, lordship.
Yes.
Can the matter be placed up to come after 2 weeks, lordship?
Why?
Lordship, Angus Council, Mr. A. Rashid is out of station, lordship.
Who?
A. Rashid, Mr. A. Rashid, Angus Council.
For whom?
For the petitioner, lordship.
There are many other councils on top of him. There are so many other councils.
Lordship, Angus, no one is available, lordship.
No one is aware.
No, no. Actually,
Are you saying that the matter was moved by Mr. Banik without knowing it?
Lordship, Angus Council, conducting council is Mr. A. Rashid, lordship.
Then
So he is out of station and the brief is along with him.
no, it can't be so. There are so many other councils. Why should this mean? What is the matter about?
Matter is about service related matter, lord. Service related matter, lord. Provincial.
Obviously, this court doesn't take up any other matters. What is the matter about?
Provincialization of a post, lordship.
It couldn't be provincialization of a post because this court is otherwise not taking up provincialization matter. Well, read it. Take it up. No adjournments. Yes. Next.
I mention listing of this case for admission because this is matter left out from the series, my lord, by stipendiary teacher. So that may be fixed up by disposal in light of that,
Which one?
my lord. For one case, my lord,
Okay.
pertaining to stipendiary teacher. This may be
Stipendiary
listed and
teacher.
disposed of.
We'll have it on when? Friday?
Lordship, lordship convenient.
Friday? 21st.
May I please, your lordship, I beg to mention item number 26.
20?
26.
26. Yes, tell me.
We need some time to file an affidavit in opposition, your lordship.
You are for that?
Sumanda, for the respondent number 1.
What is that? The Industrial Cooperative Bank. For
Yes,
what
sir.
purpose?
Okay.
Matter pertains to what?
So my senior is out of station.
No. Senior is out of station, doesn't have.
And the file,
Why the matter has come up?
actually file is not with me, your lordship. File is not.
Okay, take a second file. We'll take it up. Don't worry. We'll see whether it is necessary or not for you to file affidavit. The 2021 matter. Yes, Mr. Singh.
Lordship, I
Mr.
beg to mention item number 41.
41.
Yes, my lord, I am appearing on behalf of Mr. Astoras. He is not well, my lord. So this matter may be taken after 2 weeks, my
Lordship, I am appearing for the respondent in the same matter.
Yes.
For
We
the
have taken the
respondent,
consent.
they have taken the consent.
Item number 41.
Yes,
Yes,
my
Lordship.
Okay. Let the matter be at the request of the learned counsel for the petitioner. Matter stands adjourned for 4 weeks.
lord.
I would like to mention WBC 7859 Article 8 to 22. This matter was a family pension matter. It was last listed on 1 to 2023. Early is maybe listed the matter on 2/5/22.
Why? 25 is a good day? Huh? Absolutely no. We'll have it on 3rd of May. Yes, Mr.
May
Bora.
please, Your Lordship. Lordship, item number 5 for today's list, my lord. I may be allowed to withdraw this petition, my lord. He has got the relief, my lord.
Heard Mr. N. Bora, the learned counsel, appearing on behalf of the petitioner. Mr. Borbuzari, you are there for the finance? Mr. R. Borbuzari appears on
Withdraw.
behalf of the finance department. Elementary, no elementary. Okay. Mr. N. Bora submits that he has instructions to withdraw the instant writ petition in view of the fact that the relief sought for has been granted to the petition. Taking into account the same, the instant writ petition stands dismissed has become infraction. Yes, Mr. P.N. Sharma appears for the elementary. P.N. Sharma. Yes,
May I please, Lordship? Lordship, I beg to mention item number 10.
yes.
This matter may be allowed to withdraw, Lordship, to become infractor.
Mr. A. Bhattaji,
S.U. Ahmed.
AUM, SUMN,
Yes.
the learned counsel appearing on behalf of the petitioner submits that he appears on behalf of the petitioner, Mr. P.N. Sharma appears for the elementary education department, Mr. R. Pujari appears for the finance department. The learned counsel for the petitioner submits that he has instructions to withdraw the instant writ petition as the petitioner have already got the relief. Taking into account the same, the instant petition stands dismissed as it has become infructuous.
Matter.
May I please, Your Lordship?
Yes,
Lordship, I beg to mention item 16.
16. Why?
Yes, Lordship, with consent of the respondent, Lordship, Lordship, kindly adjourn the matter for today.
Why?
Lordship, whatever the engaged counsel is not,
You are there.
my name is not in the
The
constitution.
name is not there.
Yes, sir.
We'll look into it. 2019 matter.
Yes, sir.
Be there, ready.
May I please,
Hmm.
I beg to mention for listing, my lord, family mention matter, my lord. Last listed on 10 to 23, but
Okay, on 3-5.
May I please, Your Lordship? I beg to mention item number 2 for withdraw, my lord.
Which one?
Item number 2, my lord.
2, you want to withdraw?
Yes, my lord.
Very well. Your name?
D. Sonwal. D. Sonwal.
Miss D. Sonwal, the learned counsel for the petitioner. Mr. Ardhar appears for the WPT and DC. And Mr. R. Pujari appears for the finance. The learned counsel for the petitioner submits that she would like to, she has instructions to withdraw the instant matter.
My
Taking
lord,
into
liberty to file.
liberty, why liberty?
My lord, due to typical mistake, my lord, I will.
Typographical mistake, let the matter come. Liberty will hear. Otherwise, I don't grant liberty otherwise. Next,
May I please, Your Lordship? My lord, I beg to mention item number 13 and 14, my lord.
38,
13, 1-3, my lord.
1,
13,
3.
13 and 14, my lord.
Didn't like the number?
13,
Yes. Tell me,
my lord, the matter may be adjourned for that day, my lord.
why? 2018 matter. It doesn't look
My lord,
nice.
Engaged counsel is on medical ground, my lord, outside.
Don't worry, we'll take it up. You are AAR Rahman,
No, my lord.
Karim.
No, my lord.
None appears, we'll dismiss for default. Don't
My
worry.
lord, he instructed me, my lord, recently.
We'll take it up when the matter is called. 2018 pension, this court is sitting in the pension bench and then you say that you want to adjournment.
He not
Don't worry, we'll see why the matter is there.
obliged.
Yes, Mr. Counsel.
I wish to mention item number 42, Lordship. I pray for adjournment of the matter for 2 weeks, Lordship. I'm appearing on
42.
behalf of Lordship.
Yes.
I'm on behalf of Mr. A.J. Atya, Lordship. He's out of town.
Okay, at the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Obliged, Lordship.
Item 1 for motion.
Please, Your Lordship, the present matter pertains to non-payment of provisional pension, Your Lordship. The petitioner retired from service upon
You have not got your provisional pension.
No, your lordship. The
Why?
petitioner retired on 28th of February 2022 itself, your lordship. However, when he
28th of
retired-
February 2022.
Yes, your lordship.
Why you have not got it?
Lordship, we have submitted a representation also on 13th of
Understood. Why you have not got it? There must be something.
Lordship, the petitioner retired during suspension, your lordship.
Okay.
However, lordship, even if the petitioner retires in suspension, the disciplinary proceeding has not been concluded, your lordship. So, according to Rule 21, your lordship, till the final order of the disciplinary proceeding is passed, he has to get the pension, the pension, your lordship. Even
My lord, as the disciplinary proceeding is going on as the verbal instruction, my lord, from the department. So 2 weeks time may be allowed, my lord. I will take the instruction, my lord.
Because what is she asking is the final relief. Means normally this court passes an order for a provisional pension. Isn't it the, unless you have a disciplinary proceedings, but can you stop the provisional pension in view of 22?
No, my lord.
Let us see, where is the pension code? Yes, madam, provisional pension, can it be stopped?
no, your lordship. As per Rule 22, he has to be paid the provisional pension, your lordship.
Hmm?
Rule 22, 1, your lordship. The second part, or if he was under suspension on the date of retirement, after the date immediately preceding the date on which he was placed under suspension, but no gratuity or death from retirement gratuity shall be paid to him until the conclusion of such proceedings and the issue of final orders thereon.
So are you entitled for pension as on the date of your retirement?
Yes, your lordship. As per the rule,
When did you join your service?
lordship, in 1989, your lordship.
Let us see your appointment order. In the
Appointment.
interest of public service, please so and
We
so
have the
is hereby
joining
transferred.
letter.
Appointment order is where? When did you retire?
Lordship, on 28th of February, your lordship.
So you are
2020.
initiated, the proceedings have been initiated.
Yes, your lordship, but even lordship, he was suspended in 2016, your lordship, and the proceedings were initiated three to 4 days before he retired. Your
But then also it has been done.
lordship, but even if the proceedings are going on, he's entitled to provisional pension.
Understood, but provided you are entitled to pension. This period from you joining the service, because that if you see Rule 22,
Yes.
the period has to be taken from the date of joining till the date of suspension.
Yes, your lordship.
Do you have the qualifying as per 108?
Lordship, as per 22, as per Rule 22, the second part, your lordship, when the departmental judicial proceeding is instituted under Rule 21, he has to be paid his provisional pension if he was under suspension on the date of retirement up to the date immediately preceding the date on which he was placed under suspension, your lordship. So he has to be paid his provisional pension till 28th, till 2016, your lordship.
So
But
from
that
your
he has
date
not
of your appointment
Yes, your
till
lordship.
2016,
Yes, your lordship.
did you
Yes,
have
not
the qualifying? Because otherwise, if you are not entitled to, you don't have a qualifying, then you are not entitled to even the
Otherwise
provision.
qualified, he has his joining report, your lordship,
Yeah.
where he joined in
Those are not here. Nothing is there. To file an additional affidavit bringing on record that, madam,
yes, your lordship.
bring on record that
Lordship, page 19, otherwise annexure 1, your lordship.
Annexure 1 is a transfer order.
Yes, your lordship.
So does it say that when you were appointed?
No, your lordship.
Then?
Lordship, file an additional affidavit for the
Yes,
appointment.
better off. We'll dispose it of on the first day itself. You are only asking for provisional
Yes.
pension. We'll dispose of if you come within the qualifying period. And you get your instructions in the meantime. We'll have it on Friday. Friday or Monday? Monday.
Monday.
Have it on Monday. At the request of the learned
Monday,
counsel,
my
to
lord.
petitioner matters stands
Monday,
adjourned.
Monday, my lord, it's a holiday, my lord, 24th,
Okay, Monday is a holiday?
my lord.
Okay, we'll have it on the Wednesday,
Wednesday.
26th. Request of the learned counsel for the petitioner matters stands adjourned till 26th of April 2020.
And number 2,
Yes, Ms. D. Sonwal, why you want to withdraw with liberty?
My lord, in synopsis, my lord,
What is the mistake?
expired date wrongly, my lord, 5/5/2021.
Huh?
In a synopsis, my lord.
Synopsis. Because of synopsis, you are withdrawing. Don't worry, this court doesn't look into the synopsis. Tell me. Don't worry about this synopsis. What is your case?
My lord,
Non-payment of area salary.
yes, my lord.
Then
The petitioner was expired in 19.
you retired when?
No, during the service period, my lord.
Huh?
Petitioner was expired during the service period, my lord.
Okay, you expired during your service
Yes, my lord.
and you are to get an area amount of rupees 3,46,000 and leave encashment of 80,000. And what is this 11 lakhs business?
Pending salary, my lord.
Huh?
Pending salary.
Why haven't you got anything? Well, issue notice.
Yes,
Out Miss Disonwal, the learned. That is the only reason you wanted to withdraw. Don't worry. Out Miss Disonwal, the learned counsel for the petitioner. Mr. Ardhor appears on behalf of the respondent number 1.
1 and 3, my lord.
1
1 and
1 and 3. This is the problem.
yes, my lord.
4 is the problem. Okay. Have you served the copy upon him?
Already.
You have served upon the standing counsel?
no, my lord, doesn't, its name is not there in the corpus.
Shalom. Okay. Anyway, serving also they don't appear. 1 and 3. Mr. R. Pujari appears for the respondent number 2. Notice making it returnable on. Yes, Mr. Dhar, when? So that you can impress upon respondent number 4. Do something. Respondent number 4 is neither represented, they don't do anything.
My lord, I think on the last occasion, my lord has, through police commissioner has,
But then also, nothing is happening.
my lord, let him come once. He will come.
Issue notice making it returnable on 17th of May. 17th. Would it be okay? 17? No. We'll have it on 24th of May. Issue notice making it returnable on 24th of May. As the respondent number 1, 2, and 3 are duly represented, extra copies of the petition be served upon them by within 2 days, by 21st. The case of the petitioner herein is that the husband was employed in the office of the employed with the respondent number 4 was employed in the respondent number 4 corporation during the while on service. The husband of the petitioner expired and on account of non-payment of the area salary as well as leave encashment by the respondent number 4, the instant writ petition has been filed. Report at লিখি দিব হা 1 by 21st লিখিলো নহয় by 21st তাৰ পিছত লিখ as regards the respondent number 4 The petitioner is directed to take steps by way of registered as well as usual by 21st of April 2023. Further to that, the petitioner is also directed to effect service upon the managing director of the respondent number 4 through Dusty, routed through the registry of this fort, and file an affidavit of service on or before the next date. Huh? The respondent number 4 shall apprise this court on the next returnable date as to why the area salary as well as the leave encashment to which the petitioner claims that her husband was entitled to have not been paid to her.
Item number 3.
Yes.
May I please, your Lordship?
Yes.
Lordship, petition pertaining to Lordship, one advance increment, your Lordship.
Huh?
Advance increment for acquiring B.Ed degree, Lordship.
Similar order. Oh, that one.
Yes.
Advance increment.
Yes,
2/7/2013. That's order, na?
Yes, Lordship, I am referring, Lordship, page 69, Lordship.
Oh, my order is there.
Yes, Lordship, yes. Lordship.
Very well.
Yes.
Where is the elementary? Is
Yeah.
elementary?
Secondary, Lordship.
Secondary. Where is secondary? Yes, Mr. Sharma. This is covered by that judgment. That if they have this B.Ed or something before 2/7 something, na? What is that requirement? Hmm. 3/7/2012.
Lordship 2102, Lordship, writ petition. Mahendra Chaudhary, Manoranjan
Yes,
Chaudhary.
2102.
Lordship.
It's covered by that order. They are asking for the same thing.
Lordship.
How many petitioners? 4 petitioners.
Yes, Lord.
828 disposal report. Heard, Mr.
Yes, sir.
S. Ali, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the respondent numbers 1, 2, 3, and 4.
1 and 2.
1, 2, and 4.
And Lordship 4 is also Inspector of Schools, Baksa.
1 and 2.
Lordship.
Where is the BTC? No BTC. You serve copies?
Yes, Lord.
Very well. Any BTC counsel in your site during the day? Have you in the morning? Have you seen either Mr. P. Nayak or Mr.
P. Chaudhary.
D. Chaudhary? B. Chaudhary?
Yes, sir. Rabba.
Is he there?
I must see your.
Okay, we'll take it after some time.
Lordship.
1 p.m.
Item number 4. What are no steps?
Yes, why no steps?
Lord, it is an inadvertent mistake on my part, my lord.
Huh?
Lord,
Lordship, I am appearing
Lord,
on
he
behalf
is
of respondent
appearing.
number 4, Lordship.
Matter pertains to what?
Respondent number
Lord,
5.
pension, my lord.
Then,
My lord.
who are you?
Lord, I am the retired principal, my lord. And,
Yes. Why haven't you got the pension?
Lord, as per my lord, recent instruction, my lord, some provisional pension had been paid pursuant to the interim order passed by this honorable court.
Hmm.
And thereafter, my lord, the process they are carrying on, but the updated instruction is required, my lord. From the, I tried to contact my petitioner, my lord.
No, who is appearing for respondent number 4?
My lord, my friend is appearing, my lord. Please,
Why is he appearing?
No,
my lord,
Lordship,
he is a
respondent number
party, my lord.
5. Respondent number 5, Lordship. No,
Commissioner and Secretary to the Government Finance Department.
no, respondent
no,
number 5,
respondent
Lordship.
5 is
Private
appearing.
respondent.
Steps is required to be upon respondent number
No,
5.
what is this matter about? That is 5872.
No, Lordship.
5467.
Item 4, Lordship.
5872.
Item 4, my lord.
Oh, itu billing method. He has given a different method. Good. No file. Wrong file has come.
My lord.
Some other day.
My lord.
Next matter.
Obliged.
Item number 6.
Six. Give it to me. File is not. Wrong files. I hope the item number 5 is the right file, which has been withdrawn. Some other court files have come. All the deputy register. What is this?
Item number 4, 5467.
আপনার লোকে arrange করবো লাগে না? Court judicial time is taken.
My lord, herein the.
Yes, you are appearing for response number 5.
My friend
Yes,
is
Lordship.
appearing.
What is the name?
Lordship, actually, for the first time, I'm appearing today. During the course of the day, I will file wakalatnama.
What? Who are you?
My lord, he is the superintendent in charge,
charge.
my lord, wherefrom I did retire and I did hand over charge to this incumbent respondent. 5.
Understood, but what is your case about?
My
What,
case about,
what
my
are
lord,
you
is that-
asking for?
My lord, I was the my lord principal of Asimia Title Madrasa, my lord, and I retired, but my pensionary benefit was not paid, my lord. And
So-
that, my lord.
So then what is the role of the
Role,
respondent?
my lord, he at that relevant period of time, my lord, was required to, my lord, forward the pension papers, and but, my lord, subsequently this
But
incumbent.
is he still there? Is he, are
No,
you
no, my
still
lord,
working?
at this moment he is not there.
Then why trouble him? Will you want your pension?
Yes, yes, my lord.
Very well. Nothing else. Yes. Mr. Sharma. Why he has not got the pension? This is a matter of 2021.
21.
Yes, why he has not got the pension? When did you retire?
Lord, I retired on, my lord, 30/11/2020.
20?
2020, my lord. 30/11.
30/11/2020.
20, my lord.
Yes, why haven't you got the pension?
My lord, actually, some arrangement was there due to regarding transformation of these, my lord, madrasas into general schools, my lord. Some arrangement was there, so there was no proper authority to transmit the pension papers, my lord. Therefore, there was a delay. Subsequently, my lord, all the issues has been settled, my lord. And, my lord, I tried to contact the petitioner, my lord, day before yesterday, but, my lord, I could not contact, my lord. Perhaps he has got this provisional pension, my lord. So, my lord,
We are not on provision.
My lord.
Is it a case of provisional pension?
no, no, my lord, the whole full pensionary
Well,
benefit. My lord,
Why he has not got
my
pension?
lord, my lord.
Lordship, fix.
And why, whom have you made parties?
My lord, the parties are, my lord, the director, the commissioner.
Why
the
haven't you
director.
made the director of pension a party? You
No,
want
no.
pension?
No, 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 it is not required, my lord. It is a secondary level, my lord. The state of Assam, principal secretary, then
No,
additional.
you want pension.
My lord,
Isn't the director of pension have anything to do? Or the accountant general? Who is going to disburse it?
my lord, required, my lord, required. Accountant general is a party, my lord, is required to be a party.
Where is it? Why haven't you make them a party? Unnecessarily, you are making some other person a
My
party.
lord. Actually, my lord, my pension papers has not been processed to the accountant general's office, my lord. That's why.
Understood, but at the end of the day, how
They-
does
they-
this
they are
court
required.
pass an order in your favor?
Yes, yes, my lord. I can, I have understood.
Then what do you want to do?
Lord, I will implement them, my lord. When I,
Whom should be implemented, Mr.
the
Sharma?
accountant general, my lord, and. the-
Accountant general or the
Director of pension.
director of
The
pension?
Education Department Director of pension.
Heard Mr. A.R. Bhuiya, Mr. A.R. Bhuiya, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the respondent number 1, 2, and 3, and 4. Mr.
NZ Chaudhary.
N.Z. Chaudhary appears for the respondent number 5. Taking into account that Mr. N.J., that the respondent number 5 has no role as of now, the name of the respondent number 4 is struck off.
Five.
Respondent number 5 is struck. Mr. P.N. Sharma, the learned counsel appearing on behalf of the respondent number 1 to 4 that submits that without the director of pension being made a party to the instant proceedings, an effective read cannot be issued in the instant proceeding. Taking into account that this is a pension matter, this court impledes the director of pension having his office at Moidamgaon, Housepet Complex, Guwahati 781006 as the respondent number 5, respondent number 5 to the instant proceedings. Ago respondent number 5 to struck off. Now respondent number 5 newly completed as the respondent number 5 to the instant proceedings. Mr. S.R. Borua, who is present in the court, duly accepts notice on behalf of the respondent number 5. The learned counsel appearing on behalf of the petitioner is directed to serve a copy of the instant petition to the respondent number 5. This court fixes this matter again on 17th of May 2023. On such date, the learned counsel appearing on behalf of the respondent number 1 to 5 shall apprise this court as to the status of the petitioner's pension proposal. The petitioner's pension. Liberty is given to the petitioner to mention the matter for upgrade. Registry shall indicate the name of Mr. S.R. Borua as the learned counsel appearing for the response.
Item number 3.
Yes, Mr. Chaudhary, this is covered by this order.
Yes, Lordship.
So it page 73 actually appeals for respondent number Mr. P.N. Sharma appeals for respondent number 1 and 2.
1 and 2, Lordship.
1 and 2. Mr. P. Chaudhary appeals for respondent number 3 and 4. Learned counsel appeals as it will take paragraph 2 3 4 is not. 2, 3, 4 and 5 is not necessary. I have 6 of a liquid. Liquid play good
Item number 6 for admission.
Yes, what is the matter?
Lordship, this those illegal teachers, they have been.
Oh, illegal
subsequently-
teachers.
Lordship. All the petitioners have
That
been,
earlier matter was also something with these. It was
Lordship,
tagged
Lordship.
along with these.
item number was item number 5. Amen Gogoi.
Yeah, same thing, I suppose. No? Item number 6.
This is item number 6,
illegal teachers.
illegal teachers, but the pursuant to the cabinet decision, Lordship, all these petitioners have been offered appointment as a tutor. And
And they have accepted it.
only 2 they did not join, Lordship. Petitioner number 1 and petitioner number 3, they did not join. Lordship will find petitioner number 1 in the serial number 2.
No, this is a different number. 8474.
Lordship, that was a connected petition, linked petition.
No, we are only concerned with 8474 of 2019.
Lordship.
What is this?
Lordship will take up the 3rd page, Lordship. Those teacher, list of teachers. Serial number
Mohan Borua.
270.
Huh?
Serial number 270. Read petitioner number 1. He has
Mohan
been
Borua.
accommodated as tutor. His name appears in serial number 105 of list 2.
Appointment offered and accepted. How many petitioners are here?
There are lots of 8 petitioners. Out of the 8 petitioners, 2 petitioners they did not join.
Oh, Tuleswar Deori.
Read petitioner number 1, Mohan Borua, he did not join. And lots of read petitioner number 3,
He did not
Dambaru
join.
Chetia, he did not join.
But they have been accommodated.
They have been accommodated. All of them have been accommodated as tutors. Their name appeared in list 2.
And they were found to be illegal.
They were found to be illegal.
Illegal or
Previously,
irregular?
it was illegal. Demaji.
Heard Mr. None appears on behalf of the petitioner on call. P.N. Sharma appears on behalf of the elementary
Elementary
education department and submits that in pursuance to the decision and that the petitioner, that the appointment of the petitioner have been found to be illegal or irregular by a committee constituted by this government of Assam. And thereupon, as a one-time measure, the cabinet had taken a decision on 7/10/2020 or
20 lots.
20 or 21.
20. Decision was taken on 20.
7/10/2020 to accommodate the various illegal / irregular teachers. The Learning Council further draws the attention of an instruction being submitted by the Director of Value and Education, wherein it has been mentioned that the petitioner herein were accommodated as tutors. However, out of the 8 petitioners, the petition number 1 and petitioner number 3
1 and 3, they did not join.
have not joined. However, the other petitioners have duly accepted the appointment offered and joined their services. Taking into account the same, the Learning Council for the petitioner Elementary Education Department further submitted that one of the conditions of appointment was that the earlier all claims prior to the date of the appointment has to be waived, has to be relinquished. Taking into account that the petitioners number 2, 4, 5, 6, 7, and 8 have already joined and accepted those orders of appointment. By accepting the terms of the appointment order. The instant petition so filed becomes infructuous insofar as the petition number 2, 4, 5, 6, 7, and 8. However, as regards the petition number 1 and 3, there is, as their appointments were found to be irregular or illegal, the question of passing any directions for payment of the area salary, in the opinion of this court, would not be proper. In as much as to get the salary, and in as much as to issue a writ of mandamus, the appointment has to be legal. By following the due process. Considering the above, the instant writ petition insofar as the petitioner number 1 and 3 stands dismissed. The instructions so placed by Mr. P.N. Sharma is kept on record and marked with the letter.
Seven,
Same as item number 6. Lordship.
Same,
Same.
same you have got that also. Somebody has been appointed.
He has been appointed in 2021. Lordship.
How many petitioners?
One petitioner.
He has been appointed.
Lordship. He has been accommodated as tutor and he accepted the appointment.
Heard Mr.
MK Neo.
M.K.
Neo.
Now, the learned counsel appearing on behalf of the petitioner, Mr. P.N. Sharma appears for the Elementary Education Department and submits that the appointment of the petitioner was found by a committee constituted by the state government to be an appointment which is illegal or irregular. He further submits that in pursuance to the said order, pursuance to the said, in pursuance thereto, the government of Assam had taken a policy decision on 7/10/2020 to accommodate such teachers who were found as illegal or irregular. And accordingly, the petitioner was accommodated as a tutor by an order dated 30/1/2021, which the petitioner had duly accepted. The learned counsel for the Elementary Education Department have further submitted that one of the conditions of the order of appointment was that the petitioner cannot claim make any claim. The petitioner has to waive or relinquish all such claims prior to such appointment. The learned counsel for the petitioner have duly submitted that in pursuance to the order of appointment, the petitioner have joined by accepting the terms and conditions of the appointment order. Considering the above, the question of issuance of a writ in the present facts and circumstances of the case does not arise. Accordingly, the instant petition stands dismissed.
Here I am appearing for the finance matter.
Mr. Arbor Pujari appears for. Agoti.
8,
Same.
Then
This person has not got salary from May 1992. No instructions?
Lordship, we have filed affidavit, Lordship.
Very well.
However, the affidavit was filed February 2022.
So here the petitioner have not got a single penny. Okay, none appears on behalf of the petitioner on call. Mr. P.N. Sharma appears on behalf of the
Elementary lordship.
Education Department and Elementary Education Department, and Mr. Arbo Pujari appears for the Treasury Officer Dhemaji. The claims of the petitioner herein is that the petitioner claims the area salary since May 1992. It is the case of the petitioner that the petitioner was appointed as an assistant teacher by the Deputy Inspector of Schools Dhemaji by memo number 20067-850 dated 19/12/1989. The petitioner thereupon joined in her respective school in Jaidal, Dihingiri LP School. However, the petitioner was not paid the salary for which the petitioner filed a writ petition, being WPC number 1378/2001, seeking a direction for her salary. This court, by an order dated 5/3/2021, disposed of the said writ petition, directing the respondents to examine the claim of the petitioner, and if any amount is found payable to her, the same be paid within a period of 2 months from the date when a copy of the order was furnished to the respondent authorities. It further appears that in pursuance to the order dated 15/3/2021, passed in WPC number 1378/2001, the Deputy Inspector of Schools Dhemaji, by the order dated 31/3/2001, the petitioner was to be released the pay in the usual scale of pay from the current month and transferred by Solmari LP School. It further appears that the petitioner thereupon claims to be working in the Salmari LP School with effect from 31/3/2001. And further to that, on 29/12/2014, the personal hearing of the petitioner was taken by the District Elementary Education Officer Dhemaji, and the petitioner's documents were verified. In paragraph number 13 of the writ petition, it has been mentioned that a direction be issued that the monthly salary of the petitioner be released, which had stopped since May 1989. However, it appears from the relief sought for that the petitioner had claimed entitlement to the area salary from May 1992. It appears on record that this court had issued notice on 7/4/2017. In pursuance to that, the respondent number 1 had filed an affidavit on 16/3/2021.
Paragraph 7 and 8. was-
In paragraph number 5 of the said affidavit in opposition, the respondent number 1 disputed the appointment of the petitioner on the ground that it was not done so by following the due process as is required under the established norms. The respondent number 1 further states in his affidavit that the petitioner was never a government servant, but rather a person who claims to be appointed by the Deputy Inspector of Schools, Dhemaji, which appointment is apparently illegal and non-honest in law. It was further stated that in connection with the communication dated 31/3/2001 issued by the Deputy Inspector of School, it was mentioned that the said order was simply a transfer order to another school without any reference to any inquiry conducted by the Director of Elementary Education. It has been further mentioned that the Deputy Inspector of Schools was not the authority to comply with the order passed in WPC number 1378/2001. And the respondent number 1 further casts further mentions that the connivance of the petitioner with the persons in the office of the Deputy Inspector of Schools, Dhemaji, cannot be ruled out. It has been further mentioned that in view of various appointments being made illegal, as well as in excess to the sanctioned post, there was a screening committee so constituted by the government, not Assam Division Commissioner, screening committee constituted by the government, not Assam Division Commissioner Tezpur. But the petitioner never participated in the verification proceedings. It has been specific, it is the specific stand of the respondent number 1 in the affidavit that the petitioner was never on the service roll of the government and she had never received any salary from the date of her alleged appointment. There is no service book or any other document available for the petition in the government records. To the said affidavit so filed, the petitioner have not filed any reply. Taking into account that the petitioner have not participated in the verification proceedings, which was constituted by the government to verify the legality of appointments made to various school teachers. The question of issuing a mandamus in the present case for releasing of the salary to the petitioner from May 1992, in the opinion of this court, does not arise. Inasmuch as the petitioner have failed to show that the petitioner was appointed legally appointed as a school teacher by following the due process of law. So, considering the above, the instant petitions, considering the above, as this court does not find any merit in the instant petition, the petition stands dismissed.
Item number 9.
Why they have all chosen these type of matters today?
Today,
Huh?
so many matters, Lord.
They're tired of dictating the same type, same. What has happened here?
Here, Lordship, the petitioner has been
Same petition.
accommodated as tutor, but she did not join.
She was accommodated as tutor.
Tutor. But she did not join, Lordship.
This is also the same prayer. I think it is the same council.
Perhaps, Lordship.
Item number 9.
8 and 9. 8,
Ah, same council.
Same council, Lordship.
Mm.
Same council,
Same 89 order. Everything is same.
Lordship.
Claiming the same. Same 89 order.
Lordship.
But there is no affidavit here.
No affidavit, Lordship.
Why? The same. But she was accommodated as a tutor.
Accommodated as
You got the
tutor,
instructions here?
Lordship, Lordship. Accommodated as tutor, but she didn't join, Lordship.
What is the name?
Ranjuvani Bharali, serial number, Lordship will find at 339.
And what about the earlier one? Aparupa one? Is her name here?
No, Lordship. She was not offered an accommodation.
None appears on behalf of the petitioner on call. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. You're there? Mr. R. Bapujari appears on behalf of the Treasury Officer. The case of the petitioner herein, the instant with petition has been filed by the petitioner claiming area salary since May 1992 till the date of filing of the writ petition. The Learned Council appearing on behalf of the petitioner, the respondent Elementary Education Department had submitted that the appointment of the petitioner was illegal or irregular. And as such, the question of the petitioner getting any salary for that period did not arise. He further submitted that during the screenings committee so constituted upon verification have also come to a conclusion that the appointment of the petitioner was illegal or irregular. The government of Assam had taken a decision on 7/10/2020 to accommodate some of the teachers who were found as illegal or irregular, subject to waiver of all such claims prior thereto. The land council for the petitioner had submitted, the elementary education department had submitted that in terms to with the one-time measures so taken by the cabinet, by the government of Assam, the petitioner herein was accommodated as a tutor.
Accommodated as a tutor.
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 Lordship will find it 369, 339,
Tutor
339.
was accommodated as a tutor and was issued an order of appointment dated 31/2021. 31 or 30?
31, 2021.
20. However, the petitioner have not accepted the same. Be it as it may, one aspect of the matter is clear. That upon verification, it was being found that the petitioner's appointment was irregular or illegal. Considering the above, this court is of the opinion that the issuance of a writ of mandamus for directing the release of the area salary from May 1992 onwards, as claimed by the petitioner, cannot be issued, as the appointment of the petitioner was found to be illegal or irregular. Considering the above, the instant petition being without any merit stands dismissed. The copy of the communication so placed by Mr. P.N. Sharma is kept on record and marked with the letter X. One judgment, it could have taken care of everything. Every man. One judgment, it would have taken care of everything. I am dictating the same. Yes.
11.
11.
Yes, Mr. Bora.
Yes, my lord. My case is concerned, my lord. You are my lord. There is a court order. We have not received, not receiving salary from October 2007, my lord.
Huh?
After honorable court, I came before the honorable court, and honorable court by
And
order
area
dated, my lord,
salary
page
due.
32.
You
my lord.
have not got the salary from the month of March
My
2014
yes, my lord.
and of the area salary from 1/10/2007 to for 7 years.
Yes, this is they given in a fixed pay, but I am receiving salary from earlier from full scale, man.
Fixed pay.
Now they person to honorable court they given the fixed pay, man.
Where?
From 1/10/2007 to 28 to 2014.
You have got it?
I got it, but there is a fixed salary. But in earlier from date of joining, I am receiving salary as a scale pay, man.
Then why were you this stopped?
Stop was but during the period of 2007, all appointment, all Dhemaji 89 was stopped, and those who are in terminated in 1892. But my termination order was set by the Honorable High Court, man. And thereafter, from 2007, I came before the
Termination order was stayed.
set aside, my lord, in earlier termination order, my lord.
Okay. Why? Why was it
Yeah.
set aside?
Set aside because of the 2 times they had given the without notice they given the termination order.
Okay. Now,
Thereafter, my lord, from 2007 onward, they speak from my salary. Thereafter, I came before the honorable court. Honorable court passing our person to the division bench, allow him the salary with regularly, with effect from 2007 October. And thereafter, highly contempt petition and contempt petition before the division bench, they say that honorable learned additional advocate general says that we are going to comply with 3 months time. In the meantime, my lord, my contempt petition was closed, and thereafter they pass and superintendent Kusam and everything, and they give. Well, please make kindly say page 32, my
page 30
page 32. This is the honorable court order, my lord.
and Bora.
Yes, my lord. Accordingly, the writ petition is disposed of with the direction to the state respondent to release the salary of the petition of which has been withheld from October 2007, and thereafter.
So your petition was allowed.
Yes, ma'am.
Then why did you file again?
Yes, ma'am. Next time, file a contempt petition, my lord. and page
Why the
34.
contempt? There is another petition, 349/2009. What is that?
No, this is
Before the
another
division bench?
similar order passed, my lord.
Huh?
Page 36, my lord.
The present case will be entitled to the payment of the state is therefore directed to pay the salary of the petitioner which have been withheld from so and so person.
Page
Yeah.
36, my lord. This is the
Okay,
order
yeah.
of the contempt petition, my lord.
Okay, this contempt is closed.
Close. That they that
Demand
will
RCPL.
necessitate for that the salary are paid.
Present-
Contempt
and the
petition is
present
accordingly
commissioner
closed.
will take necessary to see the all the salaries are paid.
And thereafter,
You
page
had a contempt. You were what is his name? Hira Kumar.
Yeah,
He-
Hira
so-
Kumari Sakya.
Very well. Then
Next page 39, my lord.
creation of supernumerary
Yes,
post in respect
And
of
from
Hira Kumari. Saikya.
1/10/2007 to 28 to 2014, my lord.
Then you got the salary.
This is as a fixed
Oh, this I
payment.
remember. Similar matter was
Yes,
there, na?
yes, yes,
That day.
yes, sir.
Okay, then.
Then, my lord, thereafter is a page 41.
Hmm.
Only they give the 940 days as a fixed payment. So
Submission
thereby,
of requirement of area budget proposed in respect of so and so. So you got this amount during the pendency,
but got the amount.
but you want the regular salary.
Yes, my lord.
Yeah.
My lord,
very
there is a my lord, notification fee page 43, my lord.
Eh?
Page 43, my lord. There's a government notification page 43, and my contention page for turn into page 44, my lord.
Yes, where?
In view of the above facts and careful consider, government is pleased to take the following decision: exemption from the prescribed training to those working teacher, LP, UP
This
school.
is for the stipendary business.
But they did not give me. They say that I am not in training, but I am appointed in the 1989. I am receiving full scale till 2007, and thereafter all are stopped due to illegal, irregular, and those are terminated. Some of the teachers are terminated at the year 1992. But my termination, yes,
Tell me,
my lord,
did the earlier court
my lord,
decide
my lord.
whether your appointment was legal? If you see Justice Anima Hazarika's order,
Yes,
which you are referring to,
yes,
and in fact in the earlier case also, after
Yes.
signing the order, it came
case
to
by
my
the
mind.
division bench page for 34, my lord.
It was the earlier case, it was Ashok Posanam, Justice Ashok Posanam's order, if you remember. That matter, 225.
Yes, yes, yes. This is another case, my lord.
Same.
No. This is it by the one of the cases. My case is there in the honorable division bench, my lord, page 34.
No, that is there.
Those who are
But
termination.
have
was
they,
said-
no, here you have to look into another aspect. Why there was a necessity of creation of a supernumerary post for making payment to you?
That is because of that in
No,
2007.
can by way of court's order.
My lord. No, I have received salary regularly from 1990.
Understood, but then it was found to be illegal.
My lord.
Mr. Bora,
Yes.
all those excess teachers.
No, this is my post.
No,
was
no,
confirmed,
listen.
my lord.
No,
This is different, my lord.
Mr. Bora, kindly listen. All those excess teachers
My lord.
who were appointed in 89, 91, 92,
My lord.
all received their salaries in 2020, 2003, 2005. Everybody received.
Yes.
It only started when the government took up a decision that in 2005, 2006, that we are not going to stop the salaries till we make this proper verification.
Yes, my lord.
And in pursuance to this verification, it was found that these are the various excess teachers we were there in 2000, 2001. And they have been given. Now, why was it necessary to have a supernumerary post for payment of the salary to you?
My lord, this is the area salary. If you're going to pay, then there must be a supernumerary post created by the finance department.
No, because
Because
you
of that,
had
my lord.
no the
If
supernumerary.
my post
No,
was
Mr.
confirmed
Bora.
by the-
No, Mr. Bora.
My
The
lord.
supernumerary post is being created because there has to be a budgetary sanction to that post.
Yes.
Otherwise, in the absence of a post, you cannot pay the salary. How will they pay a salary on the basis of the court's order? Where is the finance department? Mr.
lord,
Bora?
My cases is concerned, my lord.
No.
My case
There
is
is a
concerned,
reason
my-
why. Because
my post
on that
is
day,
confirmed by
after
the
passing
authority,
that
there is a
order,
rules, my
it
lord.
reminded me.
I am going to show one letter on my lord. There is a
No.
rule.
First
If-
and
if this rule-
foremost, you have to, because the order passed by Justice Hazarika did not look into as to whether your appointment was legal or illegal. Why was the necessity for creation of a supernumerary post? It is by virtue of the court's order, there was some payment was directed to be made from 1/10/2007 to 2014. It is done very well. But what about the remaining period? How can a payment be made unless there is a post being created for that?
My lord,
They just, no,
the matter was,
with due respect to
no,
my,
when this matter
to my
was in
predecessor.
earlier litigation,
No,
my
Mr.
lord.
Bora,
My lord,
no, Mr. Bora, with due respect to my predecessor,
yes, my lord.
the order which was being passed was just following the earlier order. You see, Annexure F, they didn't look into it. It was just saying Mr. Bora had submitted that the case was in hell is squarely covered.
Yes,
And then, but did the court decide as to whether your appointment was legal, illegal? Why did they have to
no, no,
create a
my lord,
supernumerary
it-
post?
that, so similar order, my lord, annex I page 34, my lord. Which was
Mr.
on the
Bora,
basis of-
Mr. Bora, the division bench have also done the same thing. Does it mean that this court is going to follow that? No. The division bench have only followed the earlier order. Look at here. Did they consider the appointment? Because why was the necessity of creating a supernumerary post? If it was a salary to be paid against the post, no problem. They could have very well paid. But they had to create a supernumerary post. That means a post specifically only for your purpose. And that is only, if you see the order of creation of a supernumerary post, it was only because of payment of this particular salary to you for this period. Isn't it?
The supernumerary post is always personnel in nature.
Understood. And this post was only created for this particular period for complying with that order.
Yes, perhaps my lord, in order to comply with the. court order.
Absolutely.
Yes.
Because they couldn't have, because there can't be a budget sanction. The budget sanction has to be only on the basis of a post.
My lord,
Why haven't you not filed your affidavit?
yes.
You file your affidavit in this regard.
Perhaps the matter was last listed in 2018, perhaps.
No, whatever may be.
Last, we will file our affidavit.
Because here, that is the issue involved.
Lord.
Because all the courts, one court was the first matter was of Justice Sema. Justice Sema had dealt with and passed that order. I feel, means with due respect to my senior, my predecessors out here, they did not take into consideration as to whether the appointment was made legal or illegal. How can they be? Every person has a separate cause of action to get a salary. Look here, with due respect to my, see, page 32. How can there be an order being passed to that effect that the release of a salary without consideration as to whether the petitioner was appointed?
Based, my lord, earlier order, my lord, page 22 in the year of my lord, 95, my lord.
Understood. How can it be covered?
Page 2, yes, my lord.
How
Because of-
can it be
at that
covered,
time, this case
Mr. Bora? How
Seven,
can
my
it
lord,
be
they issue
covered?
only my that those who were terminated, they did not give the salary. But my termination order was set aside. So thereby honorable division bench taken the view. And on the basis of that view, my case was covered.
No. Already. You
Yes,
see,
my lord.
out here,
Page 22, my lord. Page 22, this is the order, my lord. On the
no, page 22 also, they don't look into here.
you-
You see,
everything is there, my lord.
No, what is the order? Direction to examine the case of the petition and regularize the services if the service of the other similarly situated have been regularized. The inspector is also to inquire as to whether the petitioner have been working during the period, and if it is found that they are working, then to pay the salary.
Yes.
First, there has to be a regularization. Now tell me, this order of regularization, could it be there now, taking into account that there Uma Devi has come in?
My person thereafter, my lord, my post was confirmed. My lord. There is a room.
Where is your confirmation?
Yes, my lord. There is a confirmation.
Show me.
Yes, my lord. There is a rule, my lord. If petitioner post was confirmed, that they cannot say, my lord, is the irregular.
Where?
Please make I list in my page for 30, my lord.
Huh?
Page 30.
30?
Yes, my lord.
Page 30.
Annex E. In pursuance of letter number so and so dated so and so issued by the Secretary to Government of Assam Education Department and letter number so and so issued by the Director Elementary Education Assam, the service of the following teacher of the provincialized LP schools are hereby confirmed from the date of shown against their names. My name is there, serial number 5, my lord.
Against what? Vacant post?
Yes, definitely.
No, no, where's the vacant post?
Yes, my lord. Hira Kumar Iswara Gyanendra LP school, my lord. From date of appointment so and
No,
so.
no,
date of
no, no.
confirmation,
Mr.
so and so.
Bora,
If
from
my post
no,
is
Mr.
not
Bora,
there,
from morning to
2007,
evening, I
how
am
can I
dealing with
get the
these
salary,
type
my
of
lord?
matters. Wherever there is an order of confirmation, it is done against the vacant post. There has to
If
be
there is
either
no
a creation of a
how can
post.
my post was confirmed?
No.
Or how can I receive the salary?
These are all the
and other-
illegalities which happen
They can
then.
file affidavit, my lord. I will satisfy before lord.
Because all orders of regularization or confirmation is always made against the vacant post. It can't be like this.
Till 2007, I am receiving regular scale of pay, my lord. Now they cannot. say-
Everybody got the salary. Then it was found out there were all these illegalities which were going on. In 2006, it all started 2005, 6 and 7, where all these things have happened. Heard Mr. N. Bora, the learned counsel appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of
Elementary law.
Elementary Education Department. Mr. R. Borpujari appears on behalf of the finance. Mr. Borpujari, you also file your affidavit in this because it is required. Because there are not one, there are many other matters.
They have not served copy. I will file a affidavit, but our names are not reflected in the call list.
And also my one pair is well, they may also may place before lordship my service book. also.
What?
My service. book. Everything is there in my service.
Let them file the affidavit. We'll look into it, whether there is a, you have a service book.
I have not by the.
You have a service book.
I have not there.
Do you have a service book?
Yes, service book is there, my office.
Very well. Where have you mentioned in your petition that there is a service book?
That was not mentioned, my lord.
Then?
My lord, everything is clear, my lord.
Mr. P, the instant writ petition has been filed by the petitioner claiming salary, claiming the regular payment of salary. After March 2014.
My-
Inasmuch as during the period pendency of the instant writ petition, the petitioner have received the salaries for the period from 1/10/2007 to 28/2014. The learned counsel appearing on behalf of the elementary education department, the elementary education department as well as the finance department are directed to file affidavit in the instant matter by 17th of May 2023. Let's list the matter again on 24th of May 2023. The petitioner shall be at liberty to file their reply within the said period.
What's the extra copy?
The registry shall show the name of Mr. P. N. Sharma and Mr. R. Borpujari appearing on behalf of the respondents. You file your affidavit.
Mark.
You give a copy to him. He doesn't have a copy.
12.
Yes, Mr.
The petitioner was a master role employee, my lord.
Hmm.
He was appointed on 14/8/89.
Hmm.
Thereafter regularized on 17/10/2005.
Hmm.
And he attained his age of superannuation on 36/2007.
2007.
2007.
And you were regularized on?
I was regularized on 2005, my lord. 7/10/2005. With effect from 22.
10th of?
7/10/2005.
7/10/2005.
Hmm.
Okay. Very well.
Now, my lord,
Yes, why no salary? No pension?
Lordship, first of all, this is a PWD matter. I was instructed by Mr. Rahul Dhar that he had he's on legs in court number 1, Your Lordship.
Hmm.
So far as so Lordship, if it can be taken up some pass over for the time being, Your Lordship.
Why?
For the PWDs, for the PWD department, Your Lordship.
Very well.
And so far as respond number 1 and 2 is concerned, that's the pension department, Your Lordship. 2, 3, and 4, 3, 4, and 5 are PWD. 1 and 2 is pension department.
Yes, pension?
Yes, and I'm there for the pension.
Yes.
So you Lordship, pension department, the view taken by the pension department is that he needs to complete 20 years. Without deduction and anything, total 20 years of service he has to render for getting pension as a master roll worker, Your Lordship. So
That,
Your Lordship, he
2012.
Lordship, no, from 1989 to 2007, Your Lordship. Master
89 to 2007.
7. So 18 years something. They have given themselves given it in the petition, Your Lordship. Some 18 years, 2 months or something.
You have been only given terminal.
yeah,
I can't help you. Only 1 year can be this way, that way.
Yes.
no. Total surrender, I have surrendered service, no, that is the same mistake you are committing. I 18 years, 2 months, 29 days. So if we deduct 6 years.
No. We are not concerned about AR. You see,
Yes. No, total
why
period
the
is
6 years is to be deducted?
That was the government policy.
No, that is as regards Sanjita Roy, that has been set aside. Not on that.
Now, for the
We are not-
purpose of computing pensionable service.
No,
if a
6
regu-
years is not required to be deducted.
Huh?
But the question is, if you want to come within the ambit of this office memorandum,
Yes, I can. Yes. What is that?
no, wouldn't he come within the, not on the question of office memorandum. Let us not go into that office memorandum. Your case is a master roll worker who has been not in a sanctioned post, not confirmed. That is his case. But he has been confirmed. Once he is being confirmed, doesn't it dates back to the date of his initial appointment?
Even from that initial.
Then in that case, wouldn't 108 say that only 10 years is the minimum period?
Yes,
Then why not?
yes. That is exactly my case.
Lordship, then Sanjita Roy and all.
Sanjita Roy will come in respect of other aspects. It will come in respect of master roll workers out there to that effect. You see, why is what required? You see, here if you see terminal benefits 151. This is
Annex 846, government notification.
no, here. It is in respect to this. In continuation of the department, so and so, it is reiterated that the said OM clearly lays down that the government service rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. It is in that respect it is said, without being confirmed. But here he has been confirmed. The moment he is being confirmed, doesn't it dates back to the date of initial year? Yes, Mr. Dhar.
That was
Why haven't you given the pension to the petitioner?
Why not?
My lord will go to page number 45 of the writ petition.
Yes.
My lord, this is the PWD spend. My lord, already we have forwarded this to the Accountant General in 2017. Although there we have counted it that this petitioner has rendered 12 years and 2 months. So now that 6 years plus, that will also come in, my lord. Because earlier 6 was deducted here.
No. You see, this 20 years business is only in view of this office memorandum of 6th of September 2003.
Yes.
Wherein it says that the person who is not confirmed Then also if you have rendered 20 years of service,
My lord,
then you have to give.
my lord,
He'll be entitled to pensionary benefits.
my lord.
That is the law, office memorandum. And this office memorandum springs from originally from another office memorandum of 1981. Now, what has happened in this case? The petitioner have been confirmed in 2005. Now, once the petitioner is confirmed, wouldn't this confirmation date back to the date of his initial appointment? And if it dates back to the initial appointment, applying 108, wouldn't he be entitled to? Why is the 6 years or 20 years? They have no meaning. Where are you saying about this 20 years? Where do you get this 20 years business?
No, my lord, initially, if I go by this order, 6 years is deducted.
No. Let us take 6 years also.
Yeah.
Then also it is 18 years.
18 years.
But the reason why you have not given is because he doesn't complete 20 years. Now, where do you get this 20 years business? The 20 year business comes from this office memorandum. But if it is not confirmed, but here the petition is confirmed. Isn't that your case, Mr. Dasgupta?
Yes, sir. My lord, that is my case. That is what we have resubmitted to the accountant general, the last paragraph. Now they have to
Where
take
is
a
the
call.
accountant general here?
My lord will just peruse this last.
Accountant general, you have not made him a party?
No, he's been made. It's for number 6.
No accountant general.
In view
We
of the
see
above,
only the accountant general nowadays in the newspaper. Today I was looking into the Assam Tribune.
The accountant general is for number 6.
Then where is he?
we have
All of
resubmitted.
you have not filed the affidavit.
Mr. Medhi was there. Your
We have
Lordship.
resubmitted.
Mr. Medhi was there. Your Lordship.
We have resubmitted. So,
Understood. You have resubmitted or done whatever may be.
my lord, now it is
Now the question is why they have not done it.
accountant general has to take a call.
And where is the accountant general? I am coming in 5 minutes. Get hold of him. Yes, where is the accountant general?
My lord, I have no instruction. I have no instruction.
You have no instruction.
Yes,
Get your instructions. The matter of 2018. Then looks nice. Person have not got his pension for such a long time. When?
Short time.
When?
2 weeks, sir. 2 weeks.
Number. Okay.
confirmed. Once it gets confirmed, it dates back to his date of his initial appointment. And if it gets date back to the initial appointment, which is also the stand of the line department, saying that he has 18 years of service. Now, this Sanjukta Roy's case came only in respect of the 6 years being added for that, but that is only in respect of non-confirmed posts. But he was confirmed. So under such circumstances, you will have to go back to 108. If it is 108, then he has qualifying service of 10 years. Therefore, he is entitled to. So that is the case of the petition. And this petitioner has retired in the year 2007, and almost 16 years have passed by. Do something. We'll get your instructions. 2 weeks. Mr. Adho appears for response number 3, 4, and 5. Mr. C.S. Hazarika appears for response number 1 and 2. And Mr. Adho appears for response number 6. The case of the petitioner herein is that the petitioner was initially appointed on when?
On 149.
Appointed on 1/4/1989.
Yes, sir.
As a master role worker in the Public Works Department, Mahur Road Division. Thereupon, his services were regularized on 7/10/2005 with effect from 22/7/2005. The same is apparent from a perusal of, what is your name? Where is your serial number?
Page number 14.
18. It appears from from annexure C to the writ petition.
Yes, sir. Page 14.
Thereupon, the petitioner retired from service on 30/6/2007. However, the respondent number 6
Page 45. Probably.
have rejected the pension proposal of the petitioner on the ground that the petitioner has only 12 years, 2 months, 29 days after deducting 6 years, which is less than 20 years. It is the case of the petitioner that the petitioner's service having been regularized with effect from 22/7/2005. The same dates back from the date of the petitioner's initial appointment, that is from 1/4/1989. And as such, the petitioner had (18 years, 2 months, 29 days). The learned counsel for the petitioner further submitted that applying the rule 108 of the Assam Service Pension Rules 1969, the petitioner is entitled to pension. By taking into account the entire 18 years, he is entitled to pension. The respondent number 6 is directed to apprise this court on the next date as to why the petitioner would not be entitled to the pension as claimed in the instant writ petition. Let this matter be taking into account that the petitioner had retired from service
2007.
almost 16 years back. This court fixes this matter on 8th of May 2023, on which date the learned counsel for the respondent number 6, as well as the respondent number 3 and 4, 3, 4, and 5, and learned counsel for the respondents shall apprise this court as to why the petitioner have not been paid to the pension. Liberty is given to the petitioner to mention the matter for upgrading.
A copy of the order.
Huh?
A copy of the order.
Why? You can't take a printout.
Well, the date may be fixed on 10th May, Lord.
10th of
May
May.
have a matter in the Itanagar.
10th of May.
Item 30.
Thirteen and 14 are same. Yes, what is your case?
Lordship, this matter
Morning, my
pertains
lord,
to
I am
posting
seeking
and transfer,
adjournment,
Lordship.
but I am not the entire counsel of this case.
Very well.
Otherwise,
Don't worry.
Lordship, the petitioner has got this.
What are you asking for? Let us see, look into it. Oh, transfer.
Transfer. He got the
Then
transfer.
transfer order, you want an adjournment after filing it in 2005 years before. With effect of the state that
April 18, 20th.
yes, your name?
My name, F. L. Oscar, my lord. F. L. Oscar, my lord.
Heard Mr. F.A. Oscar, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of
That's
which?
number 1, 2,
No,
3.
what department?
1, 2,
Appears
and
on
3.
behalf of the elementary education department. Mr.
Yeah, Khonikor.
Yes.
That's one of 4 and 5.
Khonikor appears for the respondent
5.
number 4 and 5. The case of the petitioner herein is that the petitioner was transferred from Rani ME School under Dimahasau district to Sri Radha Raman Goswami ME School under Karimganj district. By an order dated 12th of January 2016. Pursuant thereto, On 8th of February 2016, the authority of the NC Hills Autonomous Council, Haflong, released the petitioner so as to enable him to join his new place of posting at Sri Radha Raman Goswami ME School under Karimganj district. Subsequent thereto, on 1st of March 2016, the Inspector of Schools, Dimahasa Haflong, had also released the petitioner with immediate effect to enable him to join at Radha Raman Goswami ME School under Karimganj district. In the meantime, the petitioner was engaged in the NRC duty. Subsequent thereto, by an order dated 9th of February 2018, the petitioner was released from the NRC duty so as to enable him to join his new place of posting at Sri Radha Raman Goswami Girls ME School, Karimganj. When the petitioner went to join the said post, somebody else was appointed and posted at Radha Raman Goswami ME School. And as such, the petitioner had no place for joining. It is under such circumstances the instant writ petition has been filed, challenging the order of transfer dated 12/1/2016. And the petitioner be posted against the vacant post at Janak Kalyan Tapashil ME School, Karimganj. This court, by an order dated 27/8/2018, issued notice making it returnable by 3/10/2018. And in the meantime, directed the respondent authorities to ensure that the petitioner receives his salary and allowances. Thereupon, the matter has been listed today after a period of almost 5 years. Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, submits that on 28/20/2018, the petitioner was reposted at Janak Kalyan Tapashil ME School under the BEO North Karimganj with immediate effect, keeping all other terms and conditions of the earlier order dated 12/1/2016 same. The learned counsel appearing on behalf of the Elementary Education Department further produces an instructions issued by the District Elementary Education Officer, Karimganj, wherein it has been mentioned that the petitioner was reposted at Janak Kalyan Tapashil ME School as headmaster under BEO North Karimganj by the district. Is it by DE means Director of Elementary Education?
Also, it is by Director of Elementary
By the Director of by the Director of Elementary Education by an order dated 20/9/2018. And accordingly, the petitioner had joined Janak Kalyan Tapashi ME School on 5/10/2018 and has been discharging his duty continuously till date and has been receiving his salaries. The said instructions so produced by Mr. P.N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, is kept on record and marked with the letter X. Taking into account the said instructions, which is in terms with the relief which have been sought for by the petitioner, nothing remains to be decided in the instant writ petition, for which the instant writ petition stands closed. Unnecessarily, this is your prayer. You have got that.
14.
Now, this 14 is something else. Let's see what is 14. What are you asking for? Yes, Mr. Bora, what is he asking for?
Is seeking
Director to accord necessary sanction for the post of headmaster in the lower primary in the prescribed scale of 12 as the senior most man. We reply like to put that the picture of the post of headmaster as per the provisions. Where are the annexures 1 and 2?
My lord.
Yes, your name?
F.A. Loskar.
Heard Mr. F.A. Loskar, the learned counsel for the petitioner. Mr. P.K. Bora appears on behalf of the Elementary Education Department, and Mr. R. Barpuzari appears on behalf of the Finance Department. Mr. P.K. Bora has produced an instruction issued by the Director of Elementary Education to the effect that the Office of the Director of Elementary Education had submitted a report to the government for creation of the post of headmaster of LP school and also for upgradation of the senior most assistant teacher to headmaster. The government had informed that the charge allowance for headmaster as per the government notification dated 18/7/2017 is rupees 300, which cannot be increased. It was also informed that there is no post of headmaster in ALP school, therefore the question of redesignation is not possible. Taking into account the said stand, this court finds it appropriate to direct the Elementary Education Department to place such instructions by way of an affidavit, so that the petitioner is in a position to rebut to such statements. List the matter on 26th of May 2023. The Elementary Education Department shall file the affidavit by 19th of May. That instruction I'm not keeping it.
15.
Yes, madam.
Your Lordship, the English council is on legs in another court.
You are there. Don't worry. Your engaged counsel comes. If the case is bad, I will dismiss. If the case is good, I will allow you when you are there. Necessary order releasing the full payment. Yes, Mr. Dhar.
My lord.
What have you done with him? There is some department. The petitioner was put under suspension.
Suspension, then reinstated.
And what is your prayer? What is the what have happened to the suspension? Was pending some departmental proceedings? What have you done?
That is what, my lord. I have instruction, but it says nothing, my lord.
That is the only thing which is required. Don't you think so?
My lord, at least yes, my lord. Technically, we don't need, but still, my lord.
Because if the inquiry say put some punishment, it has to be in terms with that. Otherwise, you can't stop the salary to the petitioner. What is your instruction? Because the petitioner is only asking for regularizing that period,
Yes, sir.
as well as also for giving her the area salary for that,
Yes, sir.
isn't it?
The increment, your lord.
Huh?
My lord,
The increment, your lord.
my lord, I will place this. My lord will be able to dispose the matter with this instruction, my lord. It's a communication between, my lord, the director and the additional chief secretary, means the department, the government, my lord. So,
Director of what? Social welfare.
social welfare, my lord.
We have the honor to say that the matter pertains to release of full pay and giving the suspension of the petition. The pending. Mr. Dhar, what does the last line say?
Last paragraph, my lord.
Huh?
Yes,
As the
ma'am.
matter of establishment of the officer is being dealt with by the government. This
Government, my lord. That is what, my lord.
So the government has to take a decision.
Government has to, my lord.
Then
That is
why
what-
the government is not doing it? How can I dispose of?
I will just, my lord will fix the matter, my lord, after 10 days. In the meantime, whatever is to be done, I will do it, my lord.
Yes, sir.
See, madam? Okay, senior, you were getting it. Heard Mr. Because these are all old matters which have come after notice various times.
Oh, okay. Oh, my lord, there is another instruction from the AG.
Ah.
Uh,
How does the AG steps into now?
Accountant General, my lord.
Understood. How does the AG come into the business? Has the petitioner retired?
Not to my knowledge, your lordship. He was reinstated, like his order of suspension was quashed back in 2011, your lordship.
Oh, madam, when did you last ask your have a
Exactly.
contact with your client?
Your lordship, this is not my client. I'm actually standing up for a friend of mine.
Whatever
your
may
lordship.
be, but he has already got the money.
Yes, well, that's why, my lord.
Ah. The office accordingly really, you see, the government of Assam Social Welfare Department by the order dated 7/8/2019 has treated his suspension period with effect from 11/8/2009 to 2/11/2011 as on duty for all purposes, including payment of area salary, retirement benefits, etc., as per Rule FR 54B of the FR. This office accordingly released his area pay and allowances by office pay, leave salary, so and so dated 23/2020. The grievance is therefore taken care of. Yes,
Lordship, I'm really sorry. Lordship, I was lazy now.
understood, but you have already
Lordship,
got the
already-
relief.
But the issue is, Lordship, the area has been released, Lordship, but the payment has to be done by the BTC, Lordship. And the BTC was not the party while we filed the writ petition, Your Lordship.
But you have got the money.
No, Lordship. From BTC, because I'm presently working under the BTC, Your Lordship.
No, you see, the office accordingly released his area pay and allowances by the office pay leave salary slip. The payment has already gone.
Lordship, payment has gone to the BTC account, Your Lordship. This is the communication done by the department to the council, Your Lordship. This communication is done by the department to the council.
This is a 5/10/2021. Nothing remains in this case.
Lordship, then my Lordship, if any issues, Lordship, come up, the liberty may be disposed of, Lordship.
Where is the
Liberty
BTC?
may be given, Lordship.
Any BTC council here? BTC is not a party.
BTC was not a party, Lordship, when we filed the repetition, Lordship. Thereafter, Lordship, before we filed the repetition, I was transferred to the BTRC, Tamil, Your Lordship. That's under the BTC, Lordship. In the
No,
district of-
here who has put you under? This is done by the social welfare department.
Yes, Lordship.
Then
But
there's no
he has released
BTC
the money.
involved anywhere. Where's the BTC business? Okay, no.
That I have been transferred, Lordship.
Suspension of so and so, it was done by a suspension of area
That is in
superintendent of so
24,
and so.
Lordship, page.
Requested to intimate how the period of suspension will be treated by the senior
Yes, Lord.
accounts officer.
25.
I've asked. And then it has been informed, the government has already taken a decision
Yes, Lord.
that will be treated as a pay.
Very obliged to the government, Lordship. But the main problem is that I have not been, because I'm serving under the BTC, and my salaries, everything are given by the BTC, Your Lordship. And the BTC is not complying with the order.
Why the BTC is not complying with the order?
I filed representation also, but that was.
Where's your representation?
Lordship, I filed representation.
You
also.
filed the representation much later. When did
Yes,
you file
Lordship,
the
after this
petition?
order-
In 2019?
After the, it's like the fairness done
So
by
you
the
know,
AG department.
no,
I have done-
Mr. Counsel, you are aware of the fact that this representation which you are saying is of 2017.
No, Lordship, I'm talking about representation subsequent to this order, Your Lordship, of AG's order.
Ah.
That I complied. Thereafter, I communicated with the BTC, Lordship, by a separate representation recently. But that
Get
was-
hold of the BTC council. We'll implead him and then pass the order.
Yes, Lordship. That
Get hold of the
I'm
BTC council.
Very obliged, Lordship.
But why are you sleeping?
No, Lordship, I actually, Lordship, BTC is not the party, Lordship. What that's why I filed
No,
representation.
whose fault it is? Is it the fault of the petitioner?
Actually,
Or is it the petitioner's council?
council's fault.
Okay, we impose a cost upon you.
No,
On the legal service authority, you pay it 10,000 rupees.
Lordship, that may not be.
No, no,
Lordship.
it is required.
Lordship,
Then only
actually
you
during-
people learn.
in
Why
2000
were you sleeping? You know about this order.
Lordship,
Why didn't you inform her also?
That is the reason.
This order is there.
That is the reason I have instructed a client to file a representation to BTC so that we can file an impleadment, Lord.
Necessary.
Because the BTC has to be informed, Lord.
How
regarding
much
this
trouble
order.
are you going to give to your client?
Because, no, Lord.
This court is trying to solve the
It's like-
problems and you are
just
creating
following-
problems.
Because without him, without.
Get hold of the BTC council. We'll take it up after some time.
Yes, Lord. Much of
Pass the order.
16.
And the cost of 10,000 to you.
Lordship,
I make it 15 then.
no, Lordship, that was.
You pay to your client this
That was a bona
10,000
fide instruction,
10,000 to the legal service authority and 5,000 to the
Lordship, that was a bona fide instruction, Lordship, to the client.
get hold of your client. Yes. Not your client, really. Yes. Where is it? Yes, madam. What do you want here?
So as per the last order dated 2021 Lordship, the review petition was dismissed on.
That against the
31,
says that a
5,
review has been instituted being reviewed. Yes, what happened to review?
Review was dismissed, madam.
Very well. Now what is the judgment? What happened to the judgment? What is the petitioner asking for?
They are asking for regular pay scale, madam.
Regular pay scale.
Yes, madam. From with effect from 1/3/1999, madam.
1?
1/3/1999.
In 1999. Why?
Similarly situated persons has
That
already
is the
been
biggest problem with
given the
similarly situated
regular pay scale since the creation of post. They are basically a Hindi teacher under a scheme, my lord. Subsequently, central government scheme was discontinued, but government took a decision to absorb them, my lord. Out of my lord 401, my lord, 82 persons left out, and they are before this honorable court, and this honorable court allowed the repetition.
No, the repetition 6279. 6279 is what order?
7 and my lord, order is at page 91, my lord.
In the light of the discussion, these are disposed of by directing the respondents to pass appropriate or replacing the grievances within the period of 8 weeks. Coming to the question of waiver of rights raised by the court, there cannot be any question of waiver in respect of the fundamental rights granted to the What was the challenge made in this repetition? Huh? Yes, madam. We are not getting the help from the respondents. You help us.
Thereafter on 9/4/2018.
What was this? What is this case 6279/2012? What was this repetition filed for?
File for the lordship.
Page 103, my lord.
6279/2012 lordship.
Madam, we are not ready.
No, lordship,
Very well.
it seems so, lordship,
At the request of the learned counsel for the petitioner, matters can be adjourned for 4 weeks. If you are not ready, I can't help you. Yes.
As per last order, 7922.6, the respondent takes instruction lordship whether remaining amount has been paid or not.
Lordship, already 12 crores has been released and it has been credited to the accounts of the petitioner. Now, I have received the latest instruction yesterday, Your Lordship. We are supposed to send a supplementary budget for the remaining amount. Now, there is some mismatch which has been occurred due to the chartered accountant, Your Lordship. And as such, the utilization certificate of the 12 crores could not be placed before the government. Once it is placed, Your Lordship will submit the supplementary budget for the remaining amount.
When?
This is the instruction, Your Lordship.
When?
Within a short span of time, Your Lordship.
Within-
Lordship, may kindly
How much time?
let it fix after a month, Your Lordship. After 4 weeks, Your Lordship. In the meanwhile, I'll get the up-to-date status, Your Lordship.
Heard, Mr.
P. Sharma.
P. Sharma appearing on behalf of the petitioner. Petitioners. And Mr. G. Butler appears on behalf of the Corporation Department. The learned counsel appearing on behalf of the Corporation Department has submitted that on account of lapsing of the fund allocation, fresh budgetary proposal had to be given. And as such, some time is required. Taking into account the same, let the matter be listed on 29th of May 2023, on which date the learned counsel appearing on behalf of the Corporation Department shall apprise this court as regards the present status of the budgetary allocation.
Lord, I'm appearing for respondent number 4.
Who are you?
Public enterprisement.
You have some?
No, my lord.
No?
19.
Hey, naam to didi. Yes.
Please, Lordship. My lord, in this case, the petitioner was an Anganwadi helper, my lord. Petitioner was an Anganwadi helper, my lord. And my lord, her grievance is that she has not been paid her salary.
Terminated.
my lord will peruse the water rate 29/7/21.
Has not paid her for no.
The last paragraph,
on
my
her
lord.
part, account is inclined to direct or respondent jointly to file the affidavit within so and so, failing which the court will revoke the doctrine of non and hold that the respondent have no objection to the prayer made in the writ petition, and the court shall proceed to decide on the basis of the meeting. Then what else? This order goes against you.
My lord, they were supposed to file an affidavit in opposition.
My lord, I have instruction, my lord. I was supposed to apprise this court, my lord. Already she has received the money, my lord. That is the thing. Maybe not getting proper instruction on the like last case. I'll just put it, my lord. She is getting her, my lord.
Mr. Adhor, the additional senior government advisor has produced a copy of the written instructions dated and so which projects that the honorarium of the petitioner has been transferred to her. According, the court permits the learned counsel to obtain updated instructions. Accordingly, matter stands adjourned. Yes.
My lord, they were supposed to file an affidavit in opposition.
Forget about that. On after that, there is another order. You had to obtain instruction that you have whether you have got your money or not.
My lord, we have been informed that certain amount has been paid, but we have also been told that the entire amount has not been paid, my lord. So, my lord, if they file an affidavit,
How much has not been paid, and what amount has been paid?
my lord, if they can provide the record as to how
Who
much they
is
paid
going
each
to
month.
provide you? Who is the petitioner?
I am.
So, is he going to provide you, or you are going to provide us?
My
You
lord,
don't have a case.
no, my lord, if
Do you have a case or not after getting the money?
no, my lord, if the amount that has
Do you have the case or not after getting the money?
no, my lord.
Matter sense? Close. You were asked to obtain instructions on 18/8. We had after 2 years.
Yes, my lord,
Then you are not interested. Why should this court take the trouble at your instance?
no, my lord. Actually, if the records were available as to how much they have paid for each month,
Whose record will reveal? Your record.
the affidavit in
You are
opposition,
the petitioner. Why are you into all this thing? After the affidavit in opposition aspect is over on 18/8, this court, Mr. Dhar had placed the instruction that you have been paid the money. You were supposed to obtain instructions on 18/8/2021. What happened?
my lord, we have been instructed, my lord.
Then what is your instruction? How much you have got?
My lord, 38,000 something, but
How much you were entitled to get?
that we do not know, my lord.
Then what do you mean?
My lord, remuneration is
Mathematically
2,000
so
something,
far.
my lord. So according 2,000 something is the remuneration per month.
Hmm.
So accordingly, that
Have
was
been paid
calculated.
regularly, including the area wages as per the norms. What else? You don't have instructions. And this amount has been paid. The branch officer, you are entitled to 2,250. You have got this amount when?
My lord, that was of 2021, that instruction, my lord. Because this is the last instruction that I have placed before the court.
Which one?
Just I have.
This is the last one.
Yes, my lord.
That is of the 10th of August 2021.
Yes, my lord. So then thereafter, the petitioner is supposed to take instructions whether he has received this money.
Mr.
Suppose-
Dhar, all this while I have been asking him that only.
My lord, we have,
And the petitioner is not interested.
no, no, my lord, we have received the amount, my lord.
Then matter ends. Heard, Mr. Name?
S.H. Mahmood.
Well, so the learned counsel appearing on behalf of the petitioner, Mr. Adhor, the learned counsel appearing on behalf of the Social Welfare.
Social welfare, my lord.
Social Welfare Department. The instant writ petition has been filed. And why are you asking for a higher rate of 3,250 when the rate is 2,250? Or is it typographical error?
My lord, I don't know, my lord.
Claiming the instant writ petition has been filed by the petitioner. Seeking a writ of mandamus for a direction upon the respondents as to why the payment of honorarium with effect from 8/1/2018 till the date of filing of the writ petition at the rate of rupees 3,250 per month should not be paid by the respondent number 4 to the petitioner. How are you claiming 3,250? Is there any document to show that your appointment, you are entitled to 3,250?
No, ma'am.
The council? Why are you asking for more money? Let's stop the monthly payment of the honorarium in month, copy of the month. Honorarium is this much? It is Mr. Ardhor, the learned counsel appearing on behalf of the petitioner, has referred to the order dated 18/8/2000. 2021, wherein this court had duly recorded that the petitioner, that the honorarium of the petitioner have been, that the due honorarium to the petitioner have been transferred to her bank account being number 311-821-82504. On the basis of the said instructions, the learned counsel of the petitioner was asked to obtain instruction as regards as to whether the payment have been duly received. The said instructions have been again produced before this court, wherein it has been mentioned that the petitioner have been paid her honorarium regularly, including the area wages as per norms. It further appears from the said communication, said instruction, that the entitlement of Anganwadi helper is rupees 2,250 and not 3,250 as claimed by the petitioner. In as much as all Anganwadi helpers have been paid uniformly an amount of rupees 2,250. The copy of the instructions is kept on record and marked to the letter X. On a specific query being made by the court upon the learned counsel for the petitioner as to whether the petitioner have received the honorarium, the learned counsel for the petitioner had submitted that as per his instruction, the petitioner have received the honorarium. Taking into account the same, this court therefore disposes of this petition on the basis of the instructions so placed by Mr. Ardhor, as well as the instructions so, and as well as the submission made by the petitioner that the petitioner have been receiving her honorarium, have received the area wages as well as the, as is, and is also receiving the honorarium presently. This court further directs the respondent authorities to continue making payment of the honorarium to which the petitioner would continue to be entitled till she remains in employment. petition stands accordingly. Yes, BTC. Yes, Mr. Bora. Mr. Bora, what has happened is this. This petitioner was suspended by the Social Welfare Department. At that point of time, he was working with the BTC.
No. Thereafter he was transferred.
Huh?
When he was suspended, he was not under BTC.
No. When he was suspended, he was not under BTC, but subsequently
Reinstated?
he was reinstated and then transferred to BTC. Now, the case of the petitioner herein is to regularize this particular period of his suspension and for making payment of his area salary. Now, the government has taken a decision to treat him the period of suspension as on duty. And also, the Accountant General have also passed an order to the effect that he is entitled to the area salary and accordingly the amount has been released. Directed to be. Now, in the meantime, he is here in BTC. Now, the BTC has not cleared the payment. Although the government has done everything, that he is entitled to the area salary, the Accountant General has also given to the effect that this amount will be released. It's all given. But the BTC is not releasing it. Now, this happened recently when he was in BTC, for which he has submitted a representation. So this court intends that as the government where he was working, the Social Welfare Department have treated him to be on duty. And the Accountant General has also allowed that. I'm making the BTC a party with the direction that the BTC shall release the amount.
But the thing is that BTC doesn't have the financial power. BTC doesn't have the financial power has not been given to the BTC. The finance has not been authorized. It's a subject of the BTC. So
No, understood. No, he's just working out there. He gets the salary through the BTC.
But all the finance, this approval finance had to be approved. The moment the finance
Everything has been done.
then there is no difficulty. Otherwise, there the difficulty is
No, there is nothing else which remains.
Lordship.
You have a look at this. Have a look at it. Have a look at this.
That can be done, subject to there are two options. One option is the finance department and concurrence had to be done, or a SOPD fund is there in the BTC that should be it had been routed to the
Finance department.
finance department is because when the matter is in finance, the moment the
It is
finance
not a question of finance, it is the salary. He's entitled to have it. When the government has
entitled to,
treated
that's
it
why
as on duty, where is the question of any finance coming into the scene?
or there is a budget, my lord, the SOPD fund that through that it had to be routed. The
So
moment
we
the
direct the
finance comes,
social
that-
welfare department to make the payment. Matter ends, why should we be involved with the BTC? Direct the principal secretary, social
Authorized
welfare
subject to the
department to make the payment. As well as the office of the accountant general. You will see what is to be done. We don't involve the BTC.
Lordship may dispose of the matter, Lordship, directing Lordship, whatever.
I will direct it. Whatever you do, that is your lookout. You get your money, you pay it from your own pocket, or whatever you do, you do it. When everybody has said that his period of service is to be taken into account, the suspension period will be treated as a period of service. It is the incumbent duty of the authorities to make the payment. Matter ends. Why should I involve the BTC? Not necessary. Better off. Why should I disturb him?
Lordship, very kind enough.
You have not received the amount.
Lordship, I have not received them.
That is it. So we'll direct them. How do they pay? Make the payment. They will tell you. You make the payment. Heard, Mr.
TJ Das, your lord.
TJ Das, the learned counsel appearing on behalf of the petitioner. Mr. Arkithor appears on behalf of the Social Welfare Department. Mr. S.K. Medhi appears on behalf of the Office of the Accountant General AE Assam. The case of the petitioner herein was that the petitioner was put under suspension by an order dated 11/8/2009 by the Principal Secretary to the Government of Assam Social Welfare Department in exercise of the powers under Rule 6(1) of the Assam Service (Discipline and Appeal) Rules 1964. The petitioner thereupon was paid his subsistence allowance. However, by an order dated 2/11/2011, the respondent authorities, that is the Social Welfare Department, after a period of more than 2 years, had reinstated the petitioner and was pleased to and posted the petitioner as CDPO Uzani Majuli ICDS Project Jorhat. It is the case of the petitioner that although the petitioner was reinstated by the order dated 2/11/2011, there was no indication as to how the period of suspension was to be treated. Subsequent thereto, by an order dated 29/11/2013, the petitioner was transferred and posted as Superintendent VTRC Achukota Baksa. And the petitioner claims to be serving in the same capacity till date. It is the case of the petitioner that even after a period of 9 years have elapsed from the date of the suspension, the petitioners, the suspension period from 11/9/2009 to 20/11/2011 was not regularized by granting full pay and allowance to the petitioner, thereby treating the period of suspension as on duty. A reference was made to a communication issued by the Senior Accounts Officer, Office of the Accountant General (AE) Assam, Moidamga, AE Assam, dated 30/7/2015, which was marked to the petitioner, wherein clarification was sought for as to how to treat the period of suspension of the petitioner. As the respondent authorities have not taken any steps to do the needful for treating the period of suspension as on duty, the instant writ petition was filed by the petitioner. Seeking a writ of mandamus thereby directing the respondent authorities to pass necessary orders for releasing the full pay and allowances admissible to the petitioner during the period of suspension, and also for treating the said period as period spent on duty for all purposes. Further to that, the petitioner have also sought for a direction upon the respondent authorities to release the yearly increment due to the petitioner from the year 2009 till date. It appears on record that the said writ petition was filed on 24th of January 2019. And this court, by an order dated 30/1/2019, have issued notice, making it returnable by 4 weeks. Till date, the respondents have not filed their affidavit. It may be relevant to take note of an order being passed by this court on 11/6/2019, wherein this court categorically observed that as there was no apparent progress in the departmental inquiry, which was instituted as in the year 2011, the matter would be disposed of on the next date on the basis of the available materials if the authorities do not file their affidavit in opposition or produce the relevant records on the next date. In spite of the said order, there has been the affidavit, the respondents have not filed their affidavits. This court also finds it relevant to take note of another order dated 7/11/2022, wherein the learned standing counsel appearing on behalf of the Accountant General submitted that by a flux of time, the matter appears to have become infructuous as the grievances of the petitioner have been redressed. And the petitioner on the said occasion and the counsel for the petitioner on the said occasion sought for time to obtain instructions. Today, when the matter has been listed, the matter has been taken up, the learned counsel appearing on behalf of the petitioner submits that although that the government of Assam Social Welfare Department via an order number SWD.74/2019/41 dated 7/8/2019 had treated the period of suspension, that is with effect from 11/8/2009 to 2/11/2011, as on duty for all purposes, including payment of area salary, retirement benefits, etc., as per Rule 54B of the FR. He further submitted that the Office of the Accountant General, AE, had also instructed for release of the area pay and allowances by its office pay of the leave salary slip number GE-6/ES/SW/2675-76 dated 23/2020. However, it is the case of the petitioner that the respondents' authorities have not released the said amount to the petitioner. In fact, the petitioner have also submitted representation to the concerned respondent authorities. Yes, what happened to the disciplinary proceedings?
My lord, if I go by the instruction that I've placed before your lordship.
That is 2019.
19, my lord. So, my lord, he has retired also. Nothing happened.
He is retired?
Not retired. Your
He is still.
Lordship, the discipline never initiated, Lordship. There was no inquiry officer was also not appointed. There was no stokers also, Lord. It was never initiated.
It has not been initiated till now.
Lordship, no. Lordship, that
My
is-
lord,
that
the
is the
instruction
reason,
says
Lordship.
that only, as no disciplinary proceeding has been issued against him till date. That is the sentence, my lord. I have to go by this.
I've heard the learned counsels for the parties. Mr. Ardhor, the learned counsel appearing on behalf of the petitioner, respondent, Social Welfare Department submits upon instruction that no departmental proceedings have yet been initiated against the petitioner till date. Be that as it may, it is the government of Assam, Social Welfare Department had by the order dated 7/8/2019 have already treated the period of suspension of the petition. That is for the period from 11/8/2009 to 2/11/2011 as on duty for all purposes, including payment of the area salary, retirement benefits, etc., as per Rule 54B of the FR. Under such circumstances, the question of the petitioner not getting the salary, area pay, for the said period does not arise. In fact, the Office of the Principal Accountant General have also released the area pay and allowances by the office pay / leave salary dated 23/2020, and to the said aspect, the office pay / leave salary dated 23/2020 have also been enclosed, produced before this court. Under such circumstances, this court therefore disposes of this writ petition with a direction upon the respondent authorities, more particularly the Principal Secretary, Social Welfare Department, only him or anybody else, Principal Secretary, to ensure that the petitioner receives the area salary for the period from 11/8/2009 to 2/11/2011. After deducting the amount of subsistence allowance to which the petitioner have already been received. The same be complied with within a period of 1 month?
2 months, my lord. Because I don't know now, since this is not here, we'll have to write some
Within a
letters.
period of 2 months from the date a certified copy of the order of this order is served upon the Principal Secretary, Social Welfare Department. The instructions were produced by Mr. S.K. Medi is kept on record and marked with the letter X.
Okay. Much okay.
Twenty-one.
Yes, Mr. Sheikh.
But after filing the affidavit in opposition, I have found that I no need to press this petition.
Huh?
I no need to press this petition. I want to use it.
Mr. M.A. Sheikh appearing on behalf of, heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner. And Mr.
I'm for our revenue department.
J. Hendik appears on behalf of the respondent number 1, only one. Mr. R. Borpuzari appears on behalf of the respondent number 2. Mr. S.S. Roy appears for the respondent number 3, 4. Where R. Borpuzari appears for respondent number 2 and 5. Mr. S.S. Roy appears for respondent number 3 and 4. Mr. J. Hendik appears for respondent number 1 and 6. Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner, submits that He has instructions not to press the instant writ petition in view of the stand being taken by the respondents in their affidavit. Taking into account the same, the instant petition stands closed. Stands dismissed on withdrawal.
Obliged, Your Lord. 1 to 44.
Arata hoje.
22. 22.
Yes, Mr. Bani.
The admitted position is
There
that
is some matter where your name is there, you are not appearing some
I
number.
was not keeping well. I was supposed to go home early.
Huh?
I was not keeping well. I was supposed to go home early. That's why, perhaps.
Then,
The admitted position is that
is the matter which was mentioned?
perhaps yes.
Where? Yes, tell me.
My lord,
Is the matter where
My name-
notice was issued as far back as on 2021? We are in 2023, nothing
My
has
lord,
happened. Then also you
my
are
name-
asking for a matter to be,
my name was not sent for provincialization of my services in a senior secondary school. Page 35 would be the answer.
provincialize the post of the senior assistant at so and so in favor of the petitioner and release the salary, area salary of the petitioner. So you have to be provincialized first.
Absolutely. The law.
Have you been provincialized?
The law says, and my name was referred, but inadvertently dropped out. And this admission is at page 35.
Yes, what is this?
This is a letter by the inspector of schools of the concerned district circle, which says, and if I may read,
Anand Abdul Kalam was appointed as senior assistant by the then SS and according to the so and so. Issued that appointment. Teaching on. Now you will be provincialized under the 17 Act.
yes, but when the matter was processed under 11 Act, my name was there. At page
But you will
24.
be provincialized under the 17 Act.
True, my lord. But at the relevant point of time when my name was approved, it was there in the list. And under the act, there is one post of a senior assistant. Without that post being filled up, without my recommended name being approved, they dropped it. And this is the only crux at page 31. They approved the list.
Yes, the government, why they, you have not filed an affidavit? Your stand, madam.
Lordship, we have not received any instructions, Your Lord.
Oh,
And on the teeth of the matter, my lord,
you have no urgency?
I have the urgency, my lord.
Then why did you ask for adjournment?
102. 102 fever was there.
There were
I understand,
six,
they would have-
there
would
were
have
6
told you.
names in the council
They
list
should have-
and
they
of
should have.
which
I came down.
the ground taken is the last but one, the penultimate name from down below is not there.
Even
Can
the
that be
file-
the reason
The
why?
file was with me. They did not know that. I have come anyway. Look, since the inspector of schools have taken a stand
Hmm.
and they are not disputing it till date, affidavit, and under the rules,
They will dispute.
but this is a stand on record, my lord.
Should we apply the doctrine of non-preverse, madam?
Dr. Conte
Lordship. But just some time may be given, okay, I'll bring the instruction.
See?
I'll bring the.
Yeah. Okay, heard Mr. S. Bonik, the learned counsel appearing on behalf of the petitioner. You have not received your salary?
No,
Nothing?
Nothing. I really pray for that.
Since your appointment by the SMC?
As I'm told now, yes.
From SMC appointment you have not received?
We have not received
From 1998?
1998. I would not be so sure in saying that. But since page
No,
31.
obviously you cannot get a salary from the government unless it is provincialized.
So
it
my
doesn't
prayer from
even-
30th August 13 onwards. But my name was sent. That is there, page 24.
Mr. S. Bonik, the learned counsel for the petitioner. Miss D. Musairi appears on behalf of the which department? Secondary?
Secondary education.
Secondary Education Department. Mr. R. Bapuzari appears for the Finance Department. And you are appearing for?
Therefore, respondent number 6, madam.
What is that?
For the
Principal
principal
in
in charge.
charge.
Principal in charge of the
Mr.
particular.
So-and-so appears for respondent number 6. This court had issued notice on 17/9/2021, making it returnable by 6 weeks. Till date, the respondents have not filed their affidavits. Ms. D. Musairi, the learned counsel appearing on behalf of the Secondary Education Department, submits that they would like to file an affidavit in the instant matter. Taking into account the same, let the matter be listed on 29th of May 2023. The Secondary Education Department is directed. Anybody else is going to file affidavit? No. Directed to file their affidavit by 22nd of May 2023 without fail.
Obliged.
18.
Why there is this excess drawal?
My lord, due to wrong fixation of pay, my lord.
Who has done that?
At page 49, I went next. An order passed by district level education.
Wait, this one. I remember 537 to 573.
My lord.
Your fault.
My lord. But my lord, here, my lord. My lord, approval of finance.
No, not necessary. We set aside this excess to withdrawal. You can't recover this amount from him. It's your fault. You have wrong fixation. There's no, is there any allegation of fraud by him? No. Then we'll follow Rafiq Nasi and set aside this particular thing. Then carry out the pension. Out, Mr.
JU Loskar, my lord.
JUNM Loskar. Full name?
Jalaluddin Nur Muhammad.
JU. Full stop there, sir. JUNM Loskar. Learned counsel for the petitioner. Mr. PK Bora appears on behalf of the Elementary Education Department. Mr. SR Guru appears on behalf of the Director of Pension. Mr. R. Pujari appears on behalf of the Finance Department, and Mr. R. Dor appears on behalf of the Accountant General AE. The case of the petitioner herein is that the petitioner was initially appointed on 1/1/1974 as an assistant teacher and posted at RCME Madrasa Hatir Khar District, Kachar, Assam. Thereupon, the services of the petitioner was confirmed by an order dated 17/10/1977. Where is that order?
My lord. Confirm order is page. The next are 2, my lord. Page 40, my lord. Page 40, my lord. Is confirmation of service, my lord.
Page 40. Page 40. Quite an order dated 13/7/2000. Very difficult to appreciate.
Even page 40, my annex 2, my lord.
Was confirmed.
Confirmed is 77.
17/10/1977, as recorded in the order dated 13/7/2000. Thereupon, the petitioner retired from service on 29/2/2016. The pension papers there were sent to the office of the director of pension, wherein on account of a deficiency as pointed out by the office of the director of pension on 10/7/2019, there was excess drawal on account of a wrong fixation of pay. The deficiency, as stated in the communication dated 10/7/2019, being relevant, is quoted here in under. To page 53. Whole now one will be because it appears from the above quoted, above extracted portion, quoted portion, that the pay of the petitioner on 1/1/1981 ought to have been fixed at rupees 537. Instead, it was fixed at 573. Subsequently, the salary, the pay of the petitioner was worked out on the basis of rupees 573, which resulted in an excess amount which the petitioner received during his career, during his service. It has been mentioned that the total amount to which the total excess amount to which the petitioner have received on account of the wrong fixation of pay was rupees 4,09,993. And in that view of the matter, unless the finance department waives the said amount, the question of allowing the petitioner his pension and his other pensionary benefits have been withheld. The question, the entitlement of the petitioner towards pension and pensionary benefits have been withheld. It was duly noted In the order dated 3/4/2023 by this court, that there is no allegation of misrepresentation or fraud on the part of the petitioner which have resulted in wrong fixation of his pay. This aspect of the matter, this observation made by this court on 3/4/2023 is based upon a reading of the affidavit in opposition filed by the respondent number 3, that is the Director of Elementary Education. Today, Mr. P.K. Bora, appearing on the Learned Counsel, appearing on behalf of the Elementary Education Department, have produced an instruction issued by the Secretary to the Government of Assam, Department of School Education, dated 18/4/2023, wherein it has been mentioned that a pension case of the petitioner was returned by the Director of Pension by the communication dated 10/7/2019. Thereafter, the Director of Elementary Education had instructed the District Elementary Education Officer, Kachar, by the communication dated 8/8/2020 to furnish some information, and accordingly, the District Elementary Education Officer had submitted the information by the communication dated 16/9/2022. Subsequently, the Director of Elementary Education resubmitted the pension case in respect to the petitioner and requested to accord approval from the Finance Department for waiving the excess drawal amount of rupees 4,09,993. Inasmuch as per the office memorandum dated 27/1/2023, excess drawal beyond 3 lakhs in each individual cases, approval of the Finance Department is to be obtained. It was further submitted that after receiving the concurrence from the Finance Department, the necessary action will be taken up in accordance with law. The instructions were produced by the Learned Counsel for the Elementary Education Department is kept on record and marked with the letter X. The Learned Counsel for the petitioner, on the other hand, has submitted that the wrong fixation of pay was not on account of the petitioner. It was done by the authorities concerned, and the petitioner had no role in the same. He further submitted that this is not a case coming within the ambit of any fraud or misrepresentation on the part of the petitioner which had resulted in the wrong fixation of pay. The Learned Counsel for the petitioner further has drawn the attention to the judgment of the Supreme Court in the case of State of Punjab versus Rafiq Masi, whitewasher, and more particularly to paragraph number 18, wherein the Supreme Court had categorically observed the circumstances under which it would be impermissible and iniquitous to make recovery. This court has also heard the Learned Counsels appearing on behalf of the respondents. And as would also appear from the affidavit in opposition filed with the respondent number 3, there is no allegation whatsoever as regards any fraud or misrepresentation on the part of the petitioner which have resulted in the wrong fixation of the pay. This court further finds it relevant at this stage to refer to paragraph number 18 of the judgment of the Supreme Court in the case of Rafiq Masih's whitewash or Supra, which is extracted here in below. A perusal of paragraph number 18, Roman 2. Clearly stipulates that it would be impermissible on the part of the respondent authorities to make recovery when a person when the employee had already retired or would retire within 1 year from the date of the order of recovery. This case, the instant case, squarely falls within the ambit of paragraph 18(2) of the judgment of the Supreme Court in the case of Rafiq Masih Supra. Under such circumstances, the question of making any recovery of the amount of rupees 4,09,993 from the petitioner does not arise. It is also relevant to take note of that the petitioner had retired as on 29/2/2016. Until date, the petitioner have not been paid even the provisional pension or the DCRG on account of the wrong fixation of pay by the respondent authorities. This court therefore disposes of in the interest of justice, therefore disposes of the instant writ petition by declaring that the amount of rupees 4,09,993 cannot be recovered from the pension or the pensionary dues of the petitioner. This court further directs the respondent authorities, more particularly the Director of Pension, as well as the whom?
Director of Pension and my lord, District Elementary Education. District Elementary Educational Process.
As well as the Director of Elementary Education to take appropriate steps in that regard, so that the petitioner receives his pension as well as his pensionary dues, pensionary benefits. Forthwith, receives as expeditiously as possible, preferably within a period of 3 months from the date a certified copy of this order is submitted to the Director of Elementary Education as well as the Director of Pension. This court further observes that in view of the above declaration that the amount of rupees 4,09,993 cannot be recovered from the petitioner, the question of waiving, question of the formalities for waiving of the said amount by the Finance Department does not arise. Anything else?
No.
Enough?
I don't know. My lord, this amount was saved. Petitioner, you are till now they did not pay my lord pension amount. They enjoyed this amount, my lord, till now, my lord, up to 16 to the 23, my lord. I'm interested of my lord.
You want interest?
My lord,
in the communication dated 18
failed, my
April
lord, after 3
2023, my lord, there is a mistake, my lord. Date, my lord, regarding OM of Finance Department, my lord. It should be, my lord, 27/1/2022, my lord. Here it is typed as 27/1/2023, my lord.
সেইটো 22 কৰি দিব হা ক'বাত লিখিছে নহয় সেইটো 22 কৰি দিব হা
If they fail,
with the above observations and directions the petition stands disposed.
my lord, after 3 months, if they fail, my lord, not paid, my lord.
What?
After 3 months, if they fail, my lord, not comply this order, my lord, then my lord, some interest may be.
It is made clear that if the amount is not, if the pension as well as the, if the area pension as well as the regular pension is not paid, along with the other pensionary benefits to which the petitioner is entitled to within the period of 3 months as directed here in above,
Lordship will not.
the respondent authorities would be liable to pay interest at the rate of 15% per annum from the date of such default.
But he was, he retired as the headmaster. He had, my lord, all the knowledge of his, my lord, wrong calculation in the pay. It is also not in the affidavit.
No, tell me, who fixed it in 1981?
So 1981, my lord.
The problem arose because of that.
Yes.
It should be 537, you fix it at 573. That is your fault.
All this there, no. But
Then?
My lord,
Then why shouldn't I imply 97? 197 rule in 197? Yes.
but he retired as a headmaster. My lord.
So what?
Yes, my lord.
Headmaster, it is your, we'll apply 197. Where is that? 197 says about compulsory interest now. Where is it? You direct from 2016, as you stated. Yeah, interest on delayed payment of pension and gratuity. 197. You want that?
No.
Should I imply 197A? Be happy with what you have given. I normally don't impose interest, but you can't, because this person retired in 2016. Today, almost 7 years have passed by, and he has not got a single penny. Then why haven't you done it? This matter has been lying with the elementary education department. They have been doing all these things. Does it look nice?
20.
Yes, Mr. Das.
Yeah.
Mr. Das, when appearing on behalf of secondary, submit that the pension proposal along with the original purpose for regularization of the pension has been submitted on the month. Yes.
Yes, Lordship, we have received the proposal, Lordship. Process is going on, Lordship. May kindly allow 10 days time only, Lordship. Yes, sir.
Heard Mr. R.C. Das, the learned counsel, appearing on behalf of the petitioner. Mr. R. Borbuzari appears for the finance department. Ms. D. Musari appears on behalf of the secondary education department. Mr. S.R. Borua appears for the director of pension. And
A.R. Borua on behalf of Endeka for respondent number 9.
what is this on behalf of somebody?
A.R.
He has given you a wakalatnama. Then how are you appearing for on behalf of? You can appear only on behalf of somebody. You are a lawyer. Isn't it so? Then A.R. Borua appears for respondent number 9. A.R. Borua
A.R. I'm appearing
and Mr.
R.
R. Ahmed appears on behalf of the Accountant General A. Mr. S.R. Borua, the learned counsel, submits that the pension proposal have been the pension proposal of the petitioner is in process, and he requires an accommodation for 10 days for apprising this court as regards the status. Taking into account the same, let the matter be listed on 10th of May, on which date the learned counsel for the director of pension shall apprise this court as to the status of the petitioner's pension proposal. Liberty is given to the petitioner to mention the matter for update.
That's okay.
All right.
45.
Yes. Long orders have been passed.
Order is for order dated 29/3, my lord.
Yes.
Respondent number 6, the State Bank was directed to take steps for sending the calculation of the area to the Treasury
this
Officer
matter.
Lakhimpur, which we have done, my lord, on by
Upon retirement.
letter
and
dated
pension
3/3,
payment, the
3/4, my lord, 23. That was dispatched on 4/4 and by tracking slip, it reflects that the Treasury Officer has received the same on 6th of April.
Now you are getting the present pension you are getting.
Present time.
Only you are on the area pension from 2014 onwards. And it is the fault of the SBI.
No, my lord.
He says out here
He
that it
says,
is
my lord,
your
because
fault. He has submitted the life
for
certificate.
For
you
non-submission
lost
of the life certificate, if it is beyond, he makes the application after 1 year, then the fresh sanction has to be obtained from the Treasury Office, the sanctioning authority.
No, his allegation is different. His allegation is he has submitted to the branch manager of the SBI. But the branch manager of the SBI have lost it.
No, my lord, it is not that.
That is what he alleged. You have calculated the area pension?
Yes, my lord, we have already dispatched it. And
Then
as
what
per the
happened?
tracking slip, the Treasury Officer Lakhimpur has received the same on 6th April. This is the tracking slip. The letter which we have the letter is page 86 of my affidavit, my lord. Serial page 86.
What is this?
This is, my lord, the dispatch of the letter. Tracking slip. And it,
This letter, where is the letter?
letter is a page 86. I have already filed the affidavit. By that time, this was not.
Page 86?
Yes, my.
No, 86. When did you file your affidavit?
Affidavit was filed, my lord. It was on 11th.
Not here. You give me a copy of it. You got a copy?
I have.
Give it to me. You have sent it to whom?
To the Treasury Officer, as per the order dated 29/3, we have to send it to the Treasury Officer, not Lakhimpur, and we have done it, my lord.
Then?
And they have also received it on 6/4, but I think Treasury Officer has no instruction.
Treasury officer, what will he do? How much is the area?
Area it comes to, my lord, something 12 blocks and odd, my lord. This is not that legible, so I could not file it along with this letter.
What? You said that it is there?
No, letter is there, my lord. Calculation sheet has also been sent, but the copy is not legible. It is, so I have not annexed here with my lord.
So you have sent a non-legible copy to the others?
No, letter, the copy which they have sent to me through the mail, my lord, this copy is not legible to in my copy. They have sent the original. They have sent the original sheet to the Treasury Officer.
Then they will come up with the thing that it is not
No,
legible.
the figure, everything is there.
Then how much it is?
It is 12 lakhs and odd, 12,73,247.
You must have put it on your affidavit, how much it is.
Amount I have not put in.
Why haven't you not put it? That was the only thing we have asked you to put it. Didn't I ask you? Mr. Jalan appearing or will take necessary instruction in the matter is so to forfeit appropriate for sending the calculation to the so that the needful can be done. Then calculate the area pension for non-payment period as per the records of the man and to follow up with the government to accord sanction for the issue of area pension. Then why haven't you not put that amount? And you have filed an affidavit?
My lord, but this letter along with the calculation sheet has been sent to the Treasury Officer for doing the needful. They have to accord the sanction only. Once the sanction is accorded.
If the
and
treasury
issued by
officer
the
going to
bank,
grant
we
the
will
sanction or
credit
the
it.
director of pension is going to grant the sanction?
Through the treasury officer, it has to be done, my lord.
No. Treasury officer is only the conduit. Isn't it?
Treasury is only, my lord, the executing authority. He acts on the mandate of the director of pension or
It will
the
go to the
accountant
director of
general, as
pension.
the case may be.
Now, have you sent it to the director of pension?
I will have to take his concern. It is for the first time, my lord. They have
No,
taken-
earlier you have appeared.
So I have appeared.
You
my
have
lord.
also produced one instruction which I have marked it as X.
So it is there, my lord, but today, my lord, our name is not reflected in the cost list. That is the difficulty.
I can't help it. You have to see it from the number. Because your name clearly is appeared, Mr. Safe Communication, so placed by Mr. Arbor Pujari, Learned Council is kept on record and marked with letter X. So then,
Lordship will then post it on some other date, my lord, giving me some accommodation, my lord. Let me take the instructions as to whether he have received it or not.
very well.
I will take a handle, my lord, from my colleague.
You give a call to the treasury officer as you have received it or not, we'll take it up at 3:30. Then we can proceed further. Caller, give a call as to
Yes,
whether
yes.
he has received it.
Yes. I will take a-
Thereafter, then we can direct them. No?
My lord,
We'll take it up at 3:30.
my lord, my lord. Okay.
Then you should give a better copy.
Forty-eight.
Area salary, why he has not got for 4 years?
May I please, Lordship? Also, no instruction received, Lordship.
Oh.
And moreover, Lordship, he has not served the extra copies, Lordship.
Mr. Kanika.
I have given to my clerk, but maybe I'll provide tomorrow.
Cost? Cost for listing? Matter has come unnecessarily. Why should this court, if you have not taken the pain of seeing that your matter is doing it,
I'm deeply
then,
apologize, madam, to that, but I-
then why haven't you served a copy?
I have given to my clerk, madam, he has not given, madam.
I'm not concerned with the clerk. Then is the clerk
I
has
mean,
engaged
then,
you?
madam, deeply apologize for that, but
Then?
during the course of that, madam,
For your purpose, the matter has been delayed for 1 month, 9 days. Isn't it so?
madam,
Then?
during the course-
Mr. A. Chakraborty appearing on behalf of the
1, 6, and 8, Lordship.
respondent number 1, 6, and 8 submits that no copies of the petition has been served upon the petitioner in terms with the order dated 10/3/2023. Leaves the matter after 4 weeks.
Develop.
Made clear if the petitioner does not serve the copy of the petition during the course of the day, the instant matter. Petitioner is directed to serve a copy of the order, a copy of the writ petition, extra copies of the writ petition during the course of the day.
51.
Yes, Mr. Bora.
Lordship,
Oh, that one. Yes,
I
what
have
do you
received
get
the
it?
Number, my lord.
You got the number?
Lordship.
Very well. We incorporate it. You take the action. Madam, you are appearing there, huh? Number 3. 1 and 2. The main problem is you have not been able to do it as per your affidavit because of the number being not given. The correct permanent account number. Here's the number.
We are maintaining only the family pension account, Lordship. And employees deposit linked insurance account, Lordship. The PF account is maintained by them, establishment by said, Lordship.
Madam, have you seen your affidavit?
Yes, we have stated in our affidavit,
Let
Lordship.
us look into your affidavit again. See your affidavit, you have stated one thing.
Page number 3, my lord.
In page number 3, we have
15th line from the top.
stated that.
Yes, affidavit, yes.
15 line from the top.
Here it says, therefore, in absence of the current account number being furnished to the EPFO Central New Delhi, the position in relation to its credit towards the so-and-so could not be. Once the same is furnished to the Iman, that amount as may be payable would be deposited to the petitioner's account. Bank.
Yes, Lordship.
That is your stand.
Yes.
That is why we have been disturbing the response number 1 and 2, and they have
This is
come up
stated,
with their
relating to
instruction.
the family pension, Lordship, only, not relating with the provident fund,
Then
Lordship.
your affidavit is wrong.
Yes, yeah, in the affidavit, we have stated it, Lordship, in page number 3, line 7, Lordship. However, the EPFO regional office Delhi is only maintaining the employee's pension account and the employee's deposit link insurance account of the said establishment, though a check amounting to rupees so-and-so, rupees 6804 by check number 272072 dated 27/2/2021 was issued towards the settlement against account number DL/2227/2370, but it was later found that the said account does not pertain to the petitioner's husband, late Prafula Goswami. Lordship, this is
That is why you want the correct PF account number. That is what they are
not the PF
furnishing.
account number, Lordship. This is the account number, family pension account number.
I don't know
PF is
this.
different.
You
Lordship.
have stated
They have the trust, own trust, Lordship. This is the exempted establishment. We are maintaining only the family pension and employees deposit link insurance, Lordship. Only that much. Lordship.
So, madam, your specific stand out here is on account of proper the right account number being not given, you were not in a position to provide the petitioner the relief. That is your specific stand out here.
Yes,
Then you can't say anything else.
Yes,
You want, we can call this person concerned. We'll call this person to the court if he has filed a false
Lordship, we
affidavit.
will,
What is his name? Mr. Samuel Das. We'll ask him to be present in the court. When do you want it? When can he be present? We'll have it on 26th. We'll have it on 26th with the personal appearance of Mr. Samuel Das.
Lordship, we will, Lordship, we here in the affidavit, we have stated that, Lordship, we are only maintaining the family pension.
Miss,
accounts,
Madam, you
Lordship.
have
We are
categorically
maintaining
stated
family-
only one thing. It is on account of non-furnishing of the permanent account number. This has happened.
Relating to the family pension, Lordship.
Whatever may be. You said that immediately would be there, then the amount will be deposited in the petitioner's account.
Yes, Lordship, we will deposit it.
Then-
We will deposit it.
This is the number which he is giving. Where is the number?
My lord, in the last line, my lord, of the page, that is mentioned.
Where?
In the last line.
The PF number of late Sri Goswami is 2370 and the pension number is 2003. 2370 is there.
My lord, PF number.
And the pension
This is the
is
PF number.
200. Pension case is settled by RPC. RPC may be requested. Well, further, anything more? There's nothing else. RPC office may be requested for what? Nothing else.
My lord, I have got this only number, my lord. From this number, they can apply to the they can apply the PF, my lord.
Who?
From respondent 3, my lord.
Heard Mr. A.K. Purva, the learned counsel appearing on behalf of the petitioner. Mr. Your name?
D. Das.
D. Das appears for the respond number 1 and 2, and Miss
M. Dr.
M. Dr. appears for the respond number 3. It has been specifically mentioned in the affidavit filed by the respondent number 3.
We have
That the
explained-
correct PF account number of the husband of the petitioner has not been furnished by the respondent number 1 and 2 to the respondent number 3. It is therefore the specific stand of the respondent number 3 that in absence of the correct account number being furnished to the EPFO, bracket Central New Delhi, the position in relation to the credit towards the EPF/EDLI could not be asserted. It has been further mentioned that once the same is furnished to the EPFO, Central New Delhi, the amount as may be payable would be deposited to the petitioner's bank account. This court, by then order dated 22/3/2023, directed the respondent number 1 and 2 to provide the correct PF account number of the husband of the petitioner, so that the same can be furnished to the respondent number 3 for doing the needful. Today, the learned counsel appearing on behalf of the respondent number 2 and 3, 1 and 2, has submitted an email issued by one Mr. R.S. Chauhan, wherein it has been mentioned that the PF number of late Prafulla Goswami is 2370 and the pension number is 2003. The copy of the email has been produced before, which has been produced before this court, is kept on record and marked with the letter X. The respondent number 3 shall apprise this court on the next returnable date as to what steps have been taken pursuant to the disclosure being made by the respondent number 1 and 2 before this court today. List the matter again on 22nd of May 2023.
Public, DPO.
Public.
53.
Suspension.
One review of the suspension, 1 year without review.
Yes, madam. I remember that matter.
Lordship, Lordship.
Such heinous crimes, and you have only.
Lordship, honestly, Your Lordship, I don't want to place this order, but
Huh?
this order I do not want to place, but then since the instruction has come.
Period of suspension is hereby extended. Madam, tell me, this was done on 12/4/2023.
Lordship.
The last period of suspension was, if I remember correctly, was sometime on
29/9/2022, Your Lord. 29/9/2022.
and it finished in the month of December.
December, Your Lord.
Then how, that means during this other period, it was, there was no.
No review was done.
No, not only review. What was the position at that point of time?
Lordship, at that point of time, Your Lordship.
When you have only extended it by 90 days, what was the position thereafter? After the expiry of the period of 3 months?
Lordship, departmental proceeding was initiated. Inquiry committee was appointed. Inquiry officer was appointed, Your Lordship.
When?
Inquiry committee was constituted on 9/9/2022.
Then?
And then he was heard, the petitioner was heard on 14/9/2022.
What is the status?
Lordship, the status here is that the inquiry officer who was appointed, that person is now transferred to some other department, Your Lordship.
Then?
So it's not completed, Your Lordship.
So you are going to appoint another one?
Lordship, Lord, that is the instruction that it has been given, Your Lordship. That they are appointing a new inquiry officer.
But tell me, madam,
Lordship.
how do you take care of that particular judgment of Ajay Chaudhary, wherein it says that when you are going to review, it has to be backed by reasons.
Lordship.
What are the reasons there?
Lordship, Lordship, we also have to read Rule 6(1), because there it is the provision that is given is that pending withdrawal of departmental proceeding, Your Lordship, a person can be suspended.
Very well.
Lordship.
But whatever may be, 6(1) is there.
Lordship.
Irrespective of 6(1) being there,
Lordship.
Then also the Supreme Court has passed the law.
Lordship, that law has been passed. Your Lordship.
Then if that is the law, which have been declared to be a law now under 141,
Lordship.
can you say that these are reasons have been given?
Lordship.
And don't you think that the Director of Secondary Education have totally done away with the Supreme Court judgment in Ajay Chaudhary, saying that from 5/9/2022 till date, till finalization would be there? Wouldn't that be contrary to the judgment of the Supreme
It's
Court?
contrary. Your Lordship.
Then
Contrary. Lordship, if your Lordship allows, Lordship, I just want to place a full bench decision of Madras High Court, Your Lordship.
Yes.
There are different view has been taken.
What is the view?
The view that has been taken, Your Lordship, is that the judgment of the apex court in the case of Ajay Kumar Chaudhary does not lay down absolute proposition of law that an order of suspension cannot be continued beyond the period of 3 months if the memorandum of charges or charge sheet has not been served within 3 months, or if memorandum of charge or charge sheet is served without reason order of extension. And then the issue of challenge to the order of suspension should be analyzed on the facts of each case, considering the gravity of the charges and the rules applicable. Revocation of suspension with a direction
in a
to the
very
employer-
recent judgment of the division bench, wherein there was a request to refer Rekibud
Lordship to a
larger bench, that has been negative.
Lordship. This is the
So
full
should
bench.
I
of 3
follow
judges.
the division bench judgment of our court or the full bench of the Madras High Court? And you see, the basis of this Ajay Chaudhary judgment is not on the basis of any law, any of the provision, but on the basis of Article 21.
21.
So Article 21 being held to be the cornerstone behind this, don't you think that the declaration of the law by the Supreme Court would hold the field? More so when you have done this in this manner. Yes, what have you given, Mr. Doctor?
Lordship.
Division bench has to act.
Ojit
Ojit
Sonwal.
What does it say?
For the reasons stated herein above, we hold that there is no merit in this appeal. However, since 6(1)(a) of the rules of 1964 permits the authorities to place an employee under suspension when a disciplinary proceeding against him is contemplated or is pending, and considering the fact the disciplinary proceeding has in the meantime been initiated against respondent number 1 by serving a memorandum of charges upon him, we make it clear that this order would not come in the way of disciplinary authority from exercising jurisdiction under 6(1) of the rules of 1964 and issue a fresh order of suspension if so advised.
The division bench judgment is also there.
Okay.
Because you are going to have a fresh inquiry now, or what is the status?
Lordship, because a new inquiry officer
He
will
has
be
submitted
appointed.
his reply.
Lord-
72, my lord, page 72.
You have submitted your reply?
Yes, in this court, I quote 72 page reply.
You have submitted it or not? I'm asking you, Mr. Borua.
Submitted. Also annexed.
Lordship, some time may be given to complete the inquiry to
No,
finish
but
it.
how can you, wouldn't this be contrary to Ajay Chaudhary now? As you have not reviewed it. You see, the word used out there, reviewed it with, by giving reasonable reasons.
Reason, Lordship.
It is.
Here the word is,
Page 80.
by reasoned order must be passed for extension of the suspension. Now, if a reason order, can you say this to be a reason order? No, then. Heard Mr. M.J. Borua, the learned counsel for the petitioner. Also heard Ms. D. Musairi, the learned counsel appearing on behalf of the Secondary Education Department. What about the service upon respond number 4? Who is the respond number 4?
In charge headmaster who is now holding the charge in place of this. He was given
Respondent number 4. You have filed an affidavit, justice service. You've
Yes,
done.
my lord, we don't know those, but they deemed to be sharp. We have given registry. Yes.
Now, why do you have to make the respond number 4 a party here?
I brought some allegation against him that he's making a conspiracy. All media report, based on media report, this has
But
been
you are
done.
not really saying anything on him.
Well, I have
If
made
you
some
are
statements.
asking him that he is making a
And-
conspiracy out there.
And then my lord, my prayer is that he stop my salary. My salary means.
And he was arrested?
Yeah, yes.
Lordship.
And
You suspended him because he was arrested?
yes. He was arrested.
No,
Where's the suspension order?
page 66, your lord. 66.
56.
66. 66.
Based on media reports and
He was not arrested, your lord.
arrested, and he was
Arrested.
he's released on bail.
He was released on bail.
And quashing petition also pending. Now they will be heard.
Admin. 120. What to do with response number 4? Problem arises because of that, no?
Maybe
Service is not effective.
maybe strike them. He may not be necessary party regarding the suspension, but he has stopped my salary. I have some prayer again. That is why I made him party. Otherwise, that part.
What is your prayer?
My subsistence allowance not released
But
regularly.
you are not getting the subsistence.
We are getting, but all troubles has been made by the headmaster, that in charge, and he is the
That is the problem, no? Why you shouldn't have involved both.
And he is now in charge. That is why he is made party. I think it should be made. That is why. But in this case, he may not
But you cannot join as a headmaster of the school, huh? They will post you some other place. You can't join.
Look, that may be there.
Because that has to be. It is a specific direction will be passed because of that. But this court is very unhappy with the show cause. With these allegations, the show cause notice is very. Why do you think that with the case of allegation of POSCO, you are going to have 71, 72, and 73 minor penalty? Don't you think something needs to be done to the show cause?
Lordship, in my humble submission, Your Lordship, since inquiry has already been conducted, DP has already been initiated against him, and Your Lordship, inquiry officer has.
But this order which you have placed is.
Lordship, 2 months time may be given to complete the departmental proceeding. If that department proceeding is not completed, Your Lordship, after that he may be reinstated, Your Lordship.
Don't you think that that would be contrary to the Supreme Court judgment?
Lordship, but then we also have to see the facts and circumstances, Your Lordship, because the allegation against the petitioner is serious, Your Lordship. If he is reinstated and if he is reinstated in some other.
I can do only one thing.
Lordship.
I can give you one opportunity.
Lordship.
For giving reasons and extending the.
Lordship.
That is the only thing. But how do you take care of Deepak Malik?
Lordship.
You see, have a look at this paragraph. This paragraph of this judgment. Paragraph 12. Have a look at this. After the period of 3 months being over, can you by way of after 4 months thereafter do that?
Fault is on our part, Your Lordship. We had not reviewed the suspension order. But Your Lordship, if this person is reinstated, Your Lordship, there might
I
be
can't
some-
help it when you have initiated allegation of minor penalty.
Lordship.
Whereas in cases of person who's absent for 2-3 days,
Lordship,
you
there-
impose major penalty under 7-9.
My lord, FIR itself says that this girl is acting on the tips of others and there is no element of POCSO, my lord. And quashing petition is pending. I think this will be done. Page 56, it says that somebody instructed her to record something to kiss this headmaster that was viral, and whole story is based upon that, my lord. The inspector collected the media report, made it
No,
viral.
Mr. Borua,
Yes.
those are whatever may be, those are things which is there when you may submit when I'm sitting in the
My
criminal.
lord, please again, my lord, that he was made a conspiracy by this headmaster, my lord. On Ranjit Sharma, everything is given to him. How can I now make inquiry, my lord?
No, Mr. Borua, are you restricting yourself to only Ajoy Chaudhary and Deepak Mali, or are you saying something more than that?
My lord, my humble submission, Ajoy Chaudhary says this within 3 months, 90 days, you have to do. They have not done anything. We approached this honorable court. Then they said that, yes, we started departmental proceeding. We gave reply also. After that, they have not done anything. This honorable high court directed to within 7 days, you pass a reasonable order. They says that no, we are not handicapped, or we need time, and we extend 90 days. That was expired in December, my lord. Now he's suffered this suspension without being done. If they have not made any inquiry, and based on media report, everything is suffering.
No. Therefore, I'm asking you, are you restricting yourself only to Ajoy Chaudhary and Deepak Mali or something else?
My lord, at this page, also it was already Deepak Mali, I have.
No, that is what.
Yes, I have not.
So your contention is not beyond that.
Yes.
Not to go into all these things that who has done what.
Yes, my lord.
Ah,
but merit
you are
I
not.
cannot. Yes.
You are not on that.
Yes.
Because the moment you are on that, then this court will wait for the service upon the respondent number 4.
At this technical points, then 90
Yeah.
days.
I'm coming in 5 minutes. Huh? Madam, you have a copy of this order?
Lordship,
Kindly come to paragraph 22.
22, Your Lordship.
The primary grievance of the petitioner is the order of suspension dated so and so. However, the same order was also the subject matter of challenge in the earlier writ petition, namely so and so, in which the court by the order dated had disposed of the writ petition, remanding the matter to the respondent to undertake an exercise on the desirability to continue the suspension. Though no periodic review was made to the suspension order prior to such order of this court, which according to the law laid down by EA would have made the order unsustainable. What intrigues this court is that the petitioner accepted the said verdict of this court, and the order was never challenged nor put to review. Having accepted the said judgment and allowing the same to attain finally, the petitioner cannot be allowed to make a fresh challenge to the same order of suspension dated so and so. What is also surprising is that though the petitioner have alleged that a review of the suspension order made without following the duration even during the said action was not put to challenge at the earlier point of time, though the civil procedure as per se in the spirit very much applies to so and so. Now tell me one thing. The rights in terms with Ajoy Chaudhary is a right under Article 21.
21.
Now, can there be a waiver? Stoppel?
No.
Then this is a right which is coming from Article 21 to the petition, that you are to periodically review.
Review.
Then
That was not done.
This coordinate bench, and more particularly when the division bench says so. But in view of the division bench order, I can grant you the liberty to that effect. The last paragraph of the division bench judgment. But when in Ajoy Chaudhary, it has been categorically mandated that you can't have it beyond that. If I give you the liberty, wouldn't that be circumventing the directions passed by the Supreme Court? Which have been done by the division bench, it is okay, but that is a different aspect. But wouldn't that be amounting to circumventing the law laid down in Ajoy Chaudhary? This is a case where this very case, it is something like the petitioner's operation was successful and the petitioner died. Huh?
Lordship,
It is
here,
because of the fact that there has been a delay, not only a delay, it is more of a, you could have very well passed an order. Why haven't you passed an order? Give a reasonable order that these are the circumstances by which we need to extend.
Lordship,
Why haven't you done that?
Lordship, that was conveyed, your Lordship, but then this order was passed, your Lordship.
Since the authority seems to be in hand in glove with the petition. Otherwise, why will the show-cause notice of minor penalty being imposed upon him?
Lordship, that was also conveyed, your Lordship. Why minor punishment, so-called notice was executed?
So the authorities are not serious. It is except Miss D. Musari. Huh?
Lordship, since the facts are different, your Lordship, because serious allegations.
Understood, but
against
you
him,
don't think it to be serious.
Lordship.
The day I saw it, I was shocked to see that you have only issued show-cause only as minor penalty.
Minor.
Then you want to give him a punishment of censure in this particular thing, or only a incremental thing, or some amount to be recovered? Then some seems to be something, and the reason why you have put him under suspension is because of the people saying people have agitated against him. But can any orders being passed by the administrative authority on the basis of public pressure? I can't give you this liberty. You think it? Mr. M.J. Borua, the learned counsel appearing on behalf of the petitioner. Mr. D. Musari appears on behalf of the respondent number 1, 2, and 3. The office record shows that the office note is not clear as to whether the service upon the respondent number 4 is complete. Be that as it may, as the learned counsel for the petitioner is only agitating the further continuation of the suspension order to be bad on the ground of the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India, reported in 2015, 7 HCC 291, as well as the judgment in the case of, as well as The judgment of the Supreme Court in the case of Union of India and others versus Deepak Mali reported in 2010 2 SCC 222. The further, this court is of the opinion that the presence of the opinion that the instant repetition can be disposed of on the basis of can be disposed of in absence of the respondent number 4. The facts involved in the instant case is that the petitioner was appointed as the headmaster of which school?
Patidorong Vidyapit High School.
Patidorong Vidyapit High School by an order dated 5/8/2017 by the Joint Director of Secondary Education, by the Director of Secondary Education. Subsequent thereto, while the petitioner was rendering service as the headmaster, certain an FIR, how many FIR?
My lord, first petitioner filed FIR of blackmailing and counter plus.
No, how many FIRs have been filed against you?
One. And petitioner.
Where is
filed
that?
two. My
An
lord,
FIR was filed.
54, 50, my lord,
An FIR was filed by
by father of Hippick.
which one? Page
Page 56 and 58, my lord. 57 is extra.
56.
56 and 58. my lord.
An FIR was filed
28-3.
by one Paresh Chandra Deka.
No,
Who
my
are
lord.
Paresh Chandra Deka?
No, my lord.
Petitioner is person.
This page is 56, my lord. This Mustafa Ali, my lord. 57,
No,
my lord.
who has signed this page 56?
56 is 58, my lord. I am sorry, my lord. This is extra page coming on, my lord. I am sorry, my lord. 58 is the vernacular is 63. 63.
An FIR
62
was
is the
filed by
vernacular.
one. Where is
62,
the
63
where is the
vernacular.
document? You have not translated this.
Yes, I have translated.
Where is
It
page 62's translation?
Yes, 62 is the vernacular.
Where is the translated copy?
56 and 58. Page 56 and 50. 57 is when it wrongly come, my lord. I cannot correct it. That is good.
An FIR was filed by one Muhammad Mustafa Ali. Against the petitioner, which was registered and numbered as which police station? Kamrup. Registered and numbered as
My lord, page 63. Kindly see page PS case number
Mr.
106.
Borua, where is your pen number? Where is the number of the case?
PS case number 106 of
106, my lord.
Which police station?
My lord, Baihata Chariali PS case. In
Which was
vernacular.
registered and numbered as Baihata Sariali, Baihata PS case number
106.
106/2022. Under sections 354A, 509 of the Indian Penal Code, read with section 10 of the Protection of Children from Sexual Offense Act 2012. Thereupon, it appears that the director of secondary education had, by an order dated 4/4/2022, placed the petitioner under suspension pending drawal of departmental proceedings in exercise of the powers under Rule 6(1) of the Assam Service Discipline and Appeal Rules 1964. It further transpires from the records that the petitioner had submitted a representation dated 4/7/2022, stating inter alia that he had been released on bail by this court and even after a lapse of 90 days from the date of his suspension, there has been no reinstated. There is no, the departmental proceedings have not been initiated for which the suspension order requires to be, for which the petitioner ought to be reinstated. Subsequent thereto, on 22nd of August 2022, the disciplinary authority cum director of secondary education had issued him a show cause notice oblique the memorandum of charge containing definitive charges against the petitioner. In terms with the statement of allegation, which accompanied with, which was enclosed to the show cause notice, the charge leveled against the petitioner was that while the petitioner was in service and serving as the headmaster in Patidorong Vidyapit High School in the district of Kamrup, a news was published in the print and electronic media with photo regarding alleged involvement of sexual exploitation of the students. The local people also staged protests publicly in that regard. A case under section 354A, 509 and 106 of the Indian Penal Code was registered in Baihata Sariali Police Station against the petitioner. And accordingly, the petitioner was charged with breach of trust, cognizable offense under IPC, violation of government guidelines oblique procedure for your guidelines oblique procedure. It, however, surprises this court to take note of that in the show cause notice, the petitioner was only asked to show cause as to why penalties prescribed in clauses 1 to Roman 1 to Roman 3 of Rule 7 of the Rules of 1964 should not be inflicted upon him. This court is astonished with the show cause notice in view of the fact Estonish Agotu. Roman 1 to 3 of upon the petitioner. It may be relevant to take note of that clause 1 to Roman 3 of Rule 7 in terms with Rule 9(11), it is 11 to normal of the rules of 1964 comes within the ambit of minor penalties. It further reveals that the petitioner had submitted the reply to the show cause notice on 31/8/2022. It further appears from the records that the school wherein the petitioner was functioning as the headmaster had adopted certain resolutions for not to pay the subsistence allowance to the petitioner. Being aggrieved by such action, the petitioner being aggrieved by the such actions of the petitioner of continuation of the suspension order which was in violation to the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary, Supra, a writ petition was filed by the petitioner that before this court, which was registered and numbered as WPC number 5209/2022. This court, by an order dated 29/2022, disposed of the said writ petition. With the direction upon the respondent number 2, that is the Director of Secondary Education, to review the order of suspension of the petitioner dated 4/4/2022 and pass appropriate order within a period of 7 days from the date of receipt of the copy of the order. It was further mentioned, if the competent authority deems it necessary that the suspension of the petitioner should be extended, the reasons should be recorded for such extension, and a copy of the same should be furnished to the petitioner. It was also observed that in the event the competent authority finds that the petitioner should be reinstated back in service, appropriate order to that effect should be passed. Subsequent thereto, on 29/9/2022, the in-charge Director of Secondary Education passed a speaking order whereby the period of suspension of the petitioner was extended for a period of another 90 days. In other words, in terms with the speaking order dated 29/9/2022, the period of suspension of the petitioner would end on 30/12/2022. 30 or 29?
28, 12, 30 days, which is inclusive, 29, 12 inclusive, 28, 12.
20. On 28/12/2022. The petitioner thereupon, being aggrieved by the order of 29/9/2022, issued by the respondent number 2 herein, and the further continuation of the suspension order by the petition by the respondent authorities, have approached this court by filing a writ petition, the present writ petition, on 1st of November 2022. This court, by an order dated 4/11/2022, issued notice and further directed that a petitioner be paid the subsistence allowances within 1 month from the date of the said order, and the regular subsistence allowance, we paid the area subsistence allowance from August 2022 within 1 month from the date of the said order, and to continue the payment of the subsistence allowance to the petitioner. Thereafter, the matter has come up before this court on 12/4/2023, wherein this court made a specific query upon the learned standing counsel appearing on behalf of the Secondary Education Department as to whether there has been any extension to the suspension order dated 29/9/2022 after 29/12/2022. Today, when the matter has been listed, the learned counsel for the Secondary Education Department have placed on record an order passed by the Director of Secondary Education dated 12/4/2023, whereby the period of suspension of the petitioner was extended with effect from 5/9/2022 till the finalization of the departmental proceedings. The said order is kept on record and marked with the letter X.
Copy not served. There is a direction to serve copy. We have not. This letter is not communicated to its petitioner. My God, I only today and I can know what the extension. But direction is there to serve the copy immediately.
This court inquired with the learned counsel appearing on behalf of the Secondary Education Department as regards the status of the inquiry proceedings. The learned counsel appearing on behalf of the Secondary Education Department, with all fairness, submitted that as per her instructions, an inquiry officer was duly appointed. And during the continuation of the disciplinary proceedings, the said inquiry officer has been transferred to some other department. And as such, as per her instructions, there would be a necessity for appointing a fresh inquiry officer. I've heard the learned counsels for the parties this court would like to take note of. How the learned counsel for the parties have perused the materials on the board. This court expresses its surprise and anguish at the manner in which the respondent authorities have been dealing with the departmental proceedings of the petition, as well as the suspension of the petition. Starting from the issuance of the show cause notice, wherein the petitioner have been only asked to show cause as regards the punishment, as regards minor penalties, as envisaged under clauses Roman 1 to Roman 3 of Rule 7 of the Rules of 1964. To the order of 29, Nikki? 29?
Yes, 29.
29?
29-9.
29/9/2022, wherein the period of suspension was only extended for a period of 3 months, ending on 28/12/2022, and thereafter there has been a complete silence on the part of the respondent authorities to do the needful for extension or for reinstatement, extension of the suspension or reinstatement of the petitioner. It was only in view of the order passed on 12/4/2023. The order was passed by the in charge director of secondary education on the same date, thereby extending the period of suspension of the petitioner with effect from 5/9/2022 till finalization of departmental proceedings. In fact, the order which had been kept on record and marked with the letter X does not even take into consideration that on 29/9/2022, the period of suspension was extended for a period of 3 months, that is ending on 28/12/2022. And the authority and the disciplinary authority concerned, in a perfunctory manner, have extended the period of suspension with effect from 5/9/2022 till the finalization of the departmental proceedings. Now the question therefore arises that is it the mandate of the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary, Supra, that extension of the suspension order should be in such mechanical manner? This aspect of the matter can be seen from paragraph number 21 of the said judgment, which is reproduced hereunder. A perusal of the above judgments, above extracted portion, above paragraph, would categorically show that the currency of a suspension order should not be more than 3 months. If within the said period, the memorandum of charge / the charge sheet have not been served upon the delinquent employee, It has been further mandated that if in the circumstances the memorandum of charge the charges have been served, then a reason order must be passed for the extension of the suspension. At this stage, this court takes note of the order dated 29/9/2022. The period of suspension was only extended by 3 months. There has been no order thereafter, thereby extending the period of suspension, save and except the order passed on 12/4/2023, wherein the Director of Secondary Education, without taking note of the order dated 29/9/2022, have extended the period of suspension from 5/9/2022 till the finalization of the departmental proceedings. This court further deems it appropriate to take note of another judgment of the Supreme Court as relied upon by the learned counsel for the petitioner. That is the judgment in the case of Deepak Mali Supra, wherein the Supreme Court had interpreted Rule 6 of Sub-Rule 6 of Rule 10 of the rules of 1965 or of the Central Civil Service Classification and Control and Appeal Rules 1965, and held that an order of suspension would not survive after the period of 90 days unless it was extended after review. It was further observed in the said judgment that since no review was held within the period of 90 days, nor was there an order of extension issued within the said period, the subsequent review and extension of the order of suspension would not sustain the order, which had already become invalid after the expiry of 90 days from the date of suspension. In the instant case, as the respondent number 2 who is the disciplinary authority, having not extended the review, have not extended the period of suspension after 28/12/2022, and in the most mechanical manner have extended the suspension period of the petitioner with effect from 5/9/2022 till finalization of the departmental proceedings. This court is therefore of the view that a further continuation of the suspension of the petitioner would be contrary to the law laid down by the Supreme Court in Ajay Kumar Chaudhary Supra, as well as Deepak Mali Supra. Accordingly, this court therefore directs the respondent number 2 to reinstate the petitioner forthwith, upon a certified copy of the instant order being served upon the learned counsel appearing upon the Director of Secondary Education. This court further would observe that taking into account the allegations against which the petitioner have been charged, And the departmental proceedings is yet to be culminated. This court further directs the respondent number 2 to reinstate the petitioner in some other department.
Lordship. Because he's in headmaster, your lordship, so it is
Some other place.
some other place,
Where?
your lordship.
Not a headmaster.
Not as headmaster, your lordship.
Some other department.
Lordship.
In some other office.
Office.
In some other office of the secondary education department. Is given the liberty to transfer the petitioner to any of its office within the secondary education department so as to sever any local or personal contact that the petitioner may have and which he may misuse for obstructing the investigation against him. In respect to Baihata PS case number, an investigation against him. The respondent number 2 is also given the liberty to prohibit the petitioner from contacting any person or handling records and documents till the completion of the departmental proceedings. With the above observations and directions, the petition stands disposed.
No, may I liberty one prayer, my lord?
Yes.
One observation maybe endeavor should be taken to complete the DP, but he will retire by October. If before that some positive or negative.
This court further taking into account the just observations and directions for our. This court further would also like to take note of the submission made by the learned counsel appearing on behalf of the petitioner that the petitioner would superannuate
this year, my lord, exact date I don't know.
in
After
the
Puja vacation,
in
I
the
don't-
later part of this year, and as such submits that the departmental proceeding that direction be issued to the respondent authorities to complete the departmental proceedings as expeditiously as possible. On the other hand, the learned counsel appearing on behalf of the secondary education department submits that the director of secondary education is taking appropriate steps for appointment of a new inquiry officer. Be that as it may, this court deems it proper that the said inquiry proceedings needs to be culminated and it needs to be brought to a logical conclusion as earnestly, as expeditiously as possible, and preferably within a period of 6 months. 6 months from the date of the instant order.
Maybe 4 months, my lord, 4 or 5 months.
Tomorrow?
If good results comes, he will enter.
Oblige, your lordship.
Oblige, deeply.
23.
Yes, Mr. Bora.
Relating to this pensionary
Has been released
pension
in
and
the
pensionary
meantime, even except the
After preparing the
leave encashment
petition,
component.
pension has been released.
Madam,
my
they
lord.
have received.
All other benefit has been except the
I told you, like, it will. Yes. Except what? Leave
my
encashment.
lord,
Yes.
You have given the leave encashment also.
Leave encashment has not been given. 300 days leave. Only that amount.
Is
that
he
is
not
been-
entitled to?
No, my lord, I'm entering first time in this case, my lord. I have to do whether he is entitled or not.
You
my
see,
lord.
this CGSE has many councils.
My lord, earlier, as-
Every time another person appears and comes up and says this.
my
Does
lord,
it look
earlier
nice?
S. Sharma was appearing in this case, my lord.
He has given a practice.
No, no.
Then,
Now I am in this case, my lord.
so then tomorrow another one will appear.
No, my lord.
Then
Well, 1 week time maybe given, I'll take instruction when they will release this and get.
why leave encashment he has not got? Interest
No, ma-
you are paying?
no matter.
Who is going to pay? When did you retire?
On 31st May 2020.
2 years.
After filing the petition, my lord, they release the pension.
As per the central government, how much interest should be given?
Now bank is now around.
I am fixing it after 10 days.
Lord,
In the meantime, you just find out
Lord,
how much interest we can give.
Lord.
Hello. Ms. A. Gayan appearing on behalf of the central government standing down, appearing on behalf of the central government, submits that she have been recently asked to appear in this matter, and as such, she requires to take instruction as to whether the leave encashment have been paid to the petitioner. On the other hand, Mr. S. Bora, the learned counsel appearing on behalf of the petitioner, submits that the said amount has not been paid, except that submits that the petitioner have received all other amounts except the leave encashment.
including the regular pension. He is getting his
All
regular.
other amounts except the leave encashment. Taking into account the above, let the matter be again listed on 8th of May,
Yes.
on which date the learned counsel shall apprise this court as regards the status as to when and shall apprise this court as to whether the leave encashment amount has been paid to the petitioner.
Ask her.
I'm being item 45.
Oh, this one. Why did it become time being? The last item of the day. Oh no, that's 3:30. Yes, did you get it?
Yes.
Did the treasury officer get it?
Yes, the treasury officer received it, and my lord, on 12th of this month, my lord, he has communicated to the accountant general. In fact, my lord, the state bank authorities ought to have, my lord, sent that letter to the accountant general, not to the treasury.
But whatever they do it, but whatever means something has happened.
Yes, it is
Now
already
we can pinpoint somebody whom we need. You have sent it to the accountant general. So we'll ask Mr. Mehdi on the next page.
My lord, only one thing I want to submit, my lord. My lord, this, if it is more than 1 year, my lord, the SD has to send the pension and public grievances department, my lord, for further sanction, my lord. My lord, if we receive, my lord, it is sent on 12th of April, my lord, by registered post. So, my lord, if I will receive, my lord, we have to send pension and public.
I'll give you 1 month.
Yes, my lord.
I'm not giving you, ask you 2 months.
And if pension and public department sanction,
Mr. Mehdi, this I did it only for the purpose to know from him as to whether treasury, I knew it.
Yes.
The treasury department has no business.
Yes.
It has gone to the treasury, from the treasury, it has gone to you.
Yes.
Then you have to send it also to the line department also.
Yes.
That I know, because from the line department, the sanction will happen.
Yes.
That I know.
Yes.
But this is only for fast forwarding that what he has done. Because if I fix it again after 10 days, he will come. He said that on 12th of April I have received. So why should I lose that?
Yes.
Yes.
M. Hendik.
M. Hendik. Mr. M. Hendik, the learned counsel for the petitioner. Mr. R. Puzari appears on behalf of the finance department. Mr. Who appears for the respond number 1 and 2? Mr. A. Chakraborty appears for respond number 1 and 2. And Mr. S.K. Mehdi appears on behalf of the accountant general.
3 and 4.
AE.
3 and 4.
The learned counsel for the state bank, Mr. G. Jalan, has submitted that the amount to which the petitioner would be entitled to on account of area pension have already been calculated, and the details of which have been already sent to the office of the Treasury Officer, Lakhimpur.
Lakhimpur Treasury.
Huh?
Lakhimpur Treasury.
Lakhimpur, Treasury Officer Lakhimpur,
Yes,
on
sir.
4/4/2023. Mr. R. Pujari, the learned counsel appearing on behalf of the Treasury Officer, North Lakhimpur, had submitted that the said papers have been duly received on 12/4/2023, and the same has been thereafter forwarded to the Office of the Accountant General AE on 14,
No, on 12.
on 12/4/2023 itself.
Yes, sir.
Taking into account the same, let this matter be again listed on 24th of May 2023, on which date the learned counsel for the Accountant General, Mr. S.K. Medi, shall apprise this court as regards the status of the petitioner's area pension proposal. List accordingly.
24.
Yes, nobody is appearing. Yes, madam, what instructions you have? You are,
Yeah, I'm the phone number 4, my lord, unmarried daughter, my lord, unmarried daughter, my lord.
and
And my lord,
Who is the
he's
petitioner?
son, my lord, Major, he's the son.
then why is he filing the case?
Filing the case, my lord, he says that he has filed a succession certificate. Certificate before the Honorable Learned District Judge Nagaon.
For
And
what?
For succession of the pensionary benefit, my lord. Service
Pensionary benefits of whom?
to
Their mother.
From mother.
Mother was
expired.
working.
Yes. And
Okay, then
mother was my whole life with me, my lord. And my lord, he has not really good relation with his
mother was whole life with you.
No, I along with
Ah.
I along with my mother, my lord. But he is in separated, my lord. Now he is claiming the benefit.
He's separated from whom? From the mother.
Mother was expired.
So obviously he has to be separated.
No, at the
How
time.
can he be together with a dead person?
No. At the time before death, my lord. And there, my lord, medical expenses was done
By
me.
you.
No, my mother.
Obviously,
Yes, my lord.
if you say that you have been expending incurring the expenses for medical expenses for your mother,
My lord.
then you can't be the dependent daughter of your mother.
And in the meantime, Honorable Court state that the pensionary as an unmarried daughter, I filed in this case, my lord. They have tried to modify this into mother, my lord. And then I am getting the pension as an unmarried daughter. Regarding his service benefit is concerned, my lord, it is still today not discharged.
The service benefits he will be entitled to.
Yes, my lord. I say that.
Then
That 50% he may take, my lord, and 50% I may take. But provided that entire expenditure of the medical, that should be also, my lord, divided by 2.
Why?
Why? Because but the entire, my lord,
No,
amount.
no. If it is the expenses of the medical you have incurred,
Yes.
how can you incur? You are a dependent daughter.
But he is also responsible as a.
He's not. Forget about him. But how? If you are a dependent daughter, your entitlement is because you are a dependent daughter. You have no other source of income. Remember.
Yes, my lord.
Then how can you spend on the expenses of your mother? Isn't it matter?
No, my lord. That is actually, my lord, at the time of entire hospital, he is not a single day is visit to the hospital.
So you want to take money because of you have visited your mother.
No, not only that, my lord.
Then?
If he is interested to take the money benefit of the service benefit 50%, And the medical expenses.
Why medical expenses? You can't spend, you don't have the money. And if you have money, then you are not a dependent.
No,
We,
my lord, I
you want the
understand.
family
When
pension or
my
what?
mother was there in hospitalized, my lord, everything is there in my.
Whatever maybe, how can you spend money?
Yes,
Where do
my-
you get the money?
Yes, my lord, I am specific.
No, how did you get the money?
Yes, my lord, taking from the loan from my relatives, near relatives. I am statement was given. my lord, by
Taking
my
money
affidavit.
from the
Yes,
relative?
Yes, yes, yes.
Then we'll send it to the civil court, both of you.
Yes.
Both. And till then, till the civil court decides, nobody should get the money.
Yes, that is my prayer. my lord.
No, nobody should get the money.
Yes, that is my
Yeah.
prayer.
And your family pension also should stop.
Family pension, unmarried daughter cannot manage.
Unmarried, dependent. Dependent.
Dependent daughter. my lord.
You can't be the dependent
Dependent.
if you had the money. So that also aspect has to be looked into. Because it's after all government money.
As a unmarried daughter, I am entitled.
Unmarried daughter is not, unmarried dependent daughter.
Unmarried dependent.
You are not a dependent daughter if you have spent money.
No, I have no any income, my lord. I have no any service.
So how did you spend money?
Yes, I am in my paragraph, my lord.
Where?
In my affidavit, my lord.
Where?
Paragraph, my lord. 8, my lord. Paragraph 8 in my affidavit.
Of your affidavit?
Yes.
Where is that affidavit? For this affidavit?
Paragraph 8. May I read, my lord?
So how did you spend 3,57,398? How did you get that amount?
Yes, therefore you
13
go.
lakhs.
13 lakhs.
13 lakhs, my lord.
No, I am asking. 3,57,398. How? Where did you get it? He has only taken the loan of 10 lakhs.
Yes.
Where did you get the other money?
Because of my lord.
Where?
I think some money is there in his.
You have it. So you can't be dependent.
No, my lord, that is not correct, my lord. But your lordship is stated, my lord. They after my lord.
Nothing doing. Where is the petitioner? None appears on behalf of the petitioner on call. Ms. M.M. Kotoki appears on behalf of the respondent number
1, 2, 3.
1, 2, and 3.
My lord.
And Mr. N. Bora appears for the respondent number 4. If the petition, this court fixes the matter again on 26 on 3rd of May 2023. If none is represented, the instant petition shall be dismissed for non-prosecution on that. Madam, but you need to take note of, he's not a dependent. Because that is a very important thing. You are there in this matter. The director of pension is not there. Who is going to adjust? Accountant General. Because this needs to be taken off. It is only a dependent daughter.
Yes, sir. I have no
And if he has money to spend on the mother, then how can he be dependent?
26.
Some money from the defined way. my lord.
That is then also 10 lakhs.
26.
Yes.
My lord, the same industrial cooperative bank limited, my lord, not.
Oh,
saying
that industry. Who was taking time? You.
He was.
Tell me why.
My senior is out of it. Actually,
Very
we need
well.
time to file affidavit in opposition, sir.
While
You know.
listing the matter, the registry shall reflect the standing council of Tuan. Yes, what have you not got?
219 days salaries, my lord. Salaries during the period when the whole world was at standstill during the COVID. Those period salaries were also deducted. And all my respectful submission with your lordship, my lord. When a salary is being deducted, it's a punishment. And without following any due process, they cannot cut the salary. This is the sum and substance of the case. I have given a chart that lordship may see it even, it is in the synopsis even. I have given details for that, medical leave.
Now you have sought for leave which was not granted.
Ma'am.
126 days.
Yes, and
And
That
you
in-
have worked
that
for 93
includes-
days.
That includes periods of COVID-19. When the COVID-19 in the year 2020, if your lordship sees this chart, I've given details. Why leave was sought for, why it was not granted. All medical leaves were accompanied by, even I was suffered from COVID positive when I was declared COVID positive. That
When were
period-
you suffering from COVID positive? When did you suffer?
My lord, I'm COVID positive, my lord. I was, lordship may see the certificate, report at page 57. It is 18/5/2021.
And what was your what work did you do?
I'm a junior grade officer there.
Huh?
Junior grade officer.
You don't have a designation.
It's called junior grade officer.
Okay. So junior grade officer you were. And you were COVID positive for 39 days.
My lord, thereafter some complications arose after the suffering of COVID, my lord. And my lord, there are some other, they have not paid my salary since 2029 on many occasions. 2019, sorry.
Yes, madam. When are you filing an affidavit?
2021, my lord.
Unit, please kindly allow us 3 weeks time. 3 weeks.
3 weeks time. Why?
We have to talk with the respondent bank.
Huh?
Respondent, we have to talk with the respondent bank.
You have to talk with the respondent bank.
We have to collect some documents from them also.
Very well. But this petition was filed in 2021. Then how will you like if the respondent bank doesn't pay your fees for 3 months or 2 years, 3 years? Would you like it? Then would you not be insisting upon the respondent bank to kindly clear your fees for appearance? Then petitioner have worked. Why he shouldn't have received his salary? And you required almost 2 years it passed. Heard Mr. A. Samua, the learned counsel, appearing on behalf of the petitioner. And Miss
P. Lamu.
B.
P. Lamu.
P. Lamu appears on behalf of the industrial cooperative. What is that bank? Industrial cooperative
Industrial cooperative.
cooperative bank.
Cooperative.
The industrial cooperative bank limited.
Limited.
The claim of the petitioner herein is as regards the non-payment of salary for 216 days, to which the petitioner claims to be entitled to
219 days.
219 days. This court, by an order dated 4/9/2021, had issued notice making it returnable on 22/11/2021. Till date, no affidavit has been filed on behalf of the respondent bank. The learned counsel appearing on behalf of the respondent bank submits that she needs some accommodation so that the affidavit can be filed on behalf of the respondent bank. List the matter again on 10th of May 2023. The respondent bank, respondent number 1 bank, is directed to file their affidavit by 8th of May 2023. Okay, madam. 3 weeks.
My lord, fix a date. Fix a date, my lord, if not informed.
I fixed it on 8th of May, 10th of May.
10th of May.
I've asked them to file by 8th of May.
My lord.
27 to 35.
Page 24 पे category.
Writ petition?
Yes.
Which one?
24.
Serial number 24.
27. WPC 5300.
5300, yes.
Page 24.
Page 24.
Yes. The pending finalization
My lord, it is hereby informed to all the existing nursing personnel who joined prior to 2016 that the CAG audit has raised objection that pay fixation in respect of nursing personnel has been done erroneously since 2006. The matter is under review. The examination is refixation of pay by a team constituted by a CI wide office order dated 22/6/21 and quantum of excess payment that may be found to have been made as a result of incorrect fixation of pay shall be decided later on for recovery. However, pending finalization of excess payment made, if any, on the basis of refixation of pay as per rule, as well as CAG audit observation, it has been decided that a lump sum of ₹20,000 per month would be recovered. So on this basis, my lord, basing on the Rafiq Masjid's case, my lord.
They have retired?
No, we are working.
They are working.
If you are working, how does Rafiq Masih come in?
No. The Rafiq Masjid says more than 6 years, more than 5 years. More than 5 years you cannot recover. So therefore, my lord, justice, my lord, one judgment has been passed setting aside this judgment, setting aside this order.
My lord, in this issue, my lord, this honorable court disposed of 8 numbers of cases and directing the institute to restraining from recovery. And review petition has been filed, and these cases are pending.
Review petition, my lord, there is a stay order, and they have taken taken a plea that the petitioners have given an undertaking that they are going to refund the excess amount. In review, it has been stayed. And now the matter has to be heard, my lord. What I say, my lord, let them produce the record.
Oh, this is suspended?
Suspended, yes. Yeah. But let them produce the record, what kind of undertaking we have given. We do not know what kind of undertaking has been given in the year 2006 or any other. Let them produce the record. The matter can be finally disposed.
The post of nurse is under category
No, but Mr. Dotto, this Jagdeep Prasad, that judgment is in respect to that when the undertaking is such that there is some repetition pending, then in that regard, this amount is to be given. That we are giving you, but that we shall be subject to the outcome of this repetition.
My lord, in this case, my lord,
That is the notice. Otherwise, every time there will be a notice.
but they
Did you put them to notice? No. Did you put them to notice that this is the amount which is being paid? But this amount is being paid to them, you, subject to these proceedings, subject to that proceedings, or you may be to that effect. But that is not a notice. But this is being done by you at every point of time. Whenever you give them in a higher salary, if I could remember that matter, the cipher matter.
Yes.
The cipher matter also, in all orders of appointment, in all orders, whether in the promotion has been given or the financial upgradation has been given, and you say that yes, but this is subject to, you may be reverted back, you may lose everything. That is, can you say it to be a, can you say that to be a notice, or can you say it to be a disclaimer?
My lord, here the issue is different from that, my lord, because at the time of as per the recommendation of 7 pay commission, my lord, their pay was upgraded. And the calculation was wrong
Where?
in this case, my lord.
Okay.
This was detected by the CAG during the.
No. What was your notice issued? This is a case of review where you are saying that this judgment wouldn't apply. Rafiq Masih would not apply because Rafiq Masih was subsequently held by Jagdeep Prasad, saying that if these people were put to notice, then obviously you can't claim that they would have no notice that there was a fixation wrongly done. Also.
But this judgment was passed, my lord. In other 8 cases, this honorable court passes order taking the consideration, considering the post of nursing as grade 4. But they are category B category, my lord. The central government categorized each post basing on the pay scale, my lord.
No, they are not on 18.1. They are on 18.3.
B.
They are on 18.3. Show me that undertaking where they have given. Dispose of the method. Yes, what are you drawing here?
My lord,
so they come under group B. It's okay. Group B also, group C and D you can't as per Rafiq Masih.
Yeah.
But Rafiq Masih says various situations. One is a situation pertaining to group C and D. One is a situation where a person have retired or is about to retire within 1 year. Or a person, number 3 is a situation wherein 5 years you have been paying the excess. Now you can't make a recovery. That is one. I think they are on that.
Yes, madam. There are 5 conditions there. But
you are on the question of, you see, we have put them to notice that if any amount is to be paid in excess will be
during we have paid the amount during 2017 and 20, my lord. It was detected by the CAG, and there the process of recovery was initiated, and
you have recovered.
But due to stay,
you have not. Now show me from your document that you have to put them to notice at the time of when you are recovered. Otherwise, you come under Rafiq Masih. Only exception is this, Jagdeep Prasad.
We have given a notice. We have given notice.
Where is it? Show me that. If you are not bringing those, then where is the question of review? You are seeking review only on that basis. That judgment, you are seeking review only on that basis.
Undertaking that.
Where is the undertaking? Show it.
Undertaking, my
where is the undertaking?
Yes, my lord. In item number 29 at page
29.
Page 56, my 29. Under
page 56. Yes.
Undertaking. I hereby undertake that any excess payment that may be found to have been made as a result of incorrect fixation of.
I hereby undertake. Elect to continue on the existing pay as certain. Where is that? Oh, I hereby undertake.
Yes.
Any excess payment that may be found to have been made as a result of incorrect fixation of pay or any excess payment detected in the light of discrepancy notice subsequently will be refunded by me to the government either by adjustment against future payment due to me or otherwise.
clearly stated that.
Okay, now let's see Jagdeep Singh's judgment. You have it? Let's see Jagdeep Singh. 2016-14 SEC 260.
Para 9. Para 11. 9, 11, 12.
So you are on this paragraph 2 and 3.
Yes.
Of the judgment.
The judgment, Jagdeep Singh's judgment in para 10, 11, and 12 months.
See the facts in paragraph 2 and 3. Has anything happened to this Jagdeep Singh's judgment thereafter?
Well, it,
Because you
slight
see,
difference, but
the problem which will arise, one thing it's okay, with this judgment is there. But the problem which will arise is, every time a person gets a new salary, he will be constantly under pressure to keep this money or keep aside some money, because tomorrow you may ask that.
the Honorable Court in Rafik Masih case also was not barred recovered of from Group B category of employee. When,
Understood. But what do you say about 18.3? 18.3. Rafik Masih, there are 5 columns now. One is 18.3. Because this will, a person will be continuously under tension. That if I get a particular salary, how much do I keep it aside? Because you say that this is it. If you don't put it on notice, that this is the amount which we will be deducting, or this notice is only to this particular amount. If you don't say that, wouldn't it create a problem?
well, due to some erroneous calculation.
Understood. Very well. Under erroneous calculation, it is okay. But
6-7
how much
lakhs
does
is
the person keep? Just for example, a person concerned is getting 5,000 rupees. He has been given an upgradation to 8,000 rupees. You are putting him to notice, which is permissible as per. When you put that person to notice, and after 5 years you have continuously paid, so thereafter, how do you take care of that? Means, how do you recover that? If you recover,
My lord,
as you have put it on notice.
my lord, the payment was made during the years 2017 and 20, my lord. It was the accounts were audited, and the excess payment was detected by the tax, and immediate after that, we have taken process for recovery. Because now,
Only one thing I
as
just
per
like to
the
point out.
Rafik Masih case also,
They said, well, pending finalization of excess payment, 20,000 per month. They have not finalized what kind of excess, what kind of no notice was given. At the time of giving the fixation also, when we have given undertaking, the date is also not. In my case, there is no undertaking. They have not shown me. And this is that page 24, it says pending finalization. They have not finalized. It says they have constituted a committee. They will find out how much excess I am required.
Have you been issued notice?
Nothing, ma'am.
Nothing. Now, why are you before this court?
Before the court, because the 20,000 recovery.
Now, have they started making recovery? Have you started recovery?
Yes, to my information, my lord.
Interim order from this
Notice
court.
was issued, my lord. Notice was published, my lord. After the detection, notice was published. One
Okay,
one
okay,
petition,
okay, Mr.
submitted
Doctor.
as
Have you
representation
filed
also.
affidavit in each and every case?
Yeah.
Have you filed affidavit in each and every case?
We have filed.
No, he said that no affidavit filed in your case.
My case affidavit filed, but that undertaking was not enclosed.
He doesn't have an undertaking.
In here, I have not enclosed that, but I have statement was made, Lordship, that he had given.
And how much amount does he have to pay?
Lordship, as per this, Lordship, 20,000 per month.
How much is the amount, which is the excess amount?
They have not finalized it.
You have not finalized till now.
Lordship, may I submit, Lordship?
Please.
Lordship, the thing is that, Lordship, this they are staff nurse, Lordship. They belongs to group class 2 category, Lordship. This Rafiq Masih is 18 para 18 Roman 1, Lordship. Recovery from the employees belonging to class 3 and class 4 service, group C and group D service. So they belong to group B service, Lordship.
No, they are on 18.3.
18, but prior to that, Lordship.
Understood. There are many circumstances. Would you say that they have not retired, so it would apply to it wouldn't apply to them?
On the
You see, group C, it's 18.3 recovery from employees when the excess payment have been made for a period in excess of 5 years before the order of recovery is issued.
Yes, Lordship, but
So
here,
you cannot make it. The reason is being given in Rafiq Masih in some other place. In other paragraphs, it have been mentioned why it is not permissible. That is okay. There are various circumstances. If you see number 5, in any other case where the court arrives at the conclusion that recovery, if made from an employee, would be iniquitous or harsh or arbitrary to such an extent as would far outweigh the equitable balance of employee's right to recover. So these are many circumstances which have been enumerated. But I am asking you, have you informed what is the excess amount so that they know something? Why you have not till now found out what is the excess?
I'm paying from serial number 29 to.
Okay, in 29 also, have you mentioned how much
Yes,
amount
yes,
is in
mentioned, my
excess?
Sir, in 29, my lord. 29, 7,62,154.
7,52,000.
No different, my lord.
7,88,000. In item number 28, Lordship, it is 7,88,313.
How much?
7,88,313.
So you are going to deduct?
Yes. Here overpayment.
And
Not above 8 lakhs and not below 6 lakhs, my lord.
You get a list.
My lord,
Madam, your amount is not there.
No, Lordship. My case was filed previously, Lordship. At that time, the total amount in my affidavit, the total amount is not met.
Hello, we fix it on some other day. You can file an additional affidavit. And Mr. Das, kindly find out what can be done. Have you seen this Jagdeep Singh?
yes, sir. There the notice at the time of appointment itself, the condition was there. If any excess payment is there,
This is what is being done every time. No, this is not at the time of appointment. No, at the time of promotion.
promotion,
You
yes.
see, that is why I'm saying
At the
paragraph
time of
2.
promotion, yes.
The facts lie in a narrow compass. The respondents were appointed as civil judge junior division on Iman and was promoted as additional civil judge in the judicial service chair. By notification dated a pay scale of so and so. Senior scale was allowed under the Haryana so and so. Under the rules, each officer was required to submit an undertaking that any excess which is found to have been paid will be refunded to the government either by adjustment against future payment, due or otherwise. The respondent furnished an undertaking and was granted the revised so and so. While opting for the revised pay scale, the respondent undertook to refund any excess payment if it was so and so. So that is for everybody, it has been done.
They were placed at a notice also, para 11, whom the payment was made in the first instance was clearly placed on notice that any payment found to have
So
been
that is the
made
notice they are
in
referring to. This is the notice which they have
Let
referring
them
to.
produce the record, let us see what kind of undertaking I have given the undertaking which is there in 29. I didn't, because the client doesn't know anything about what we have written in the year 2006. Let them produce the undertaking.
Lordship, I'm sorry, Lordship, it's already mentioned here, Lordship. Page 7, Roman
So you have
7.
given the undertaking in respect
yes.
to Rasul
7,62,167.
2728, that undertaking is not with me.
undertaking.
Yes, I have stated that they have given undertaking.
Bring it on record, those undertakings,
Lordship.
and you have a where they have signed it. This is the signing. This is the undertaking at page 33. This is item number what? 3663.
27.
No. 5300 is
27.
There is no undertaking.
Yes, Lordship, page 6, last paragraph, Lordship. Further, the government servant while implementing 6 and 7 submitted an undertaking that in the event of wrong
Bring on
situation.
record that undertaking, because they don't remember.
So for all cases, Lordship,
Absolutely. In the one case there is.
But the date is not there.
No date.
No, no date is there.
No date is there.
No date.
I have annexed the undertaking in all cases.
Let them produce the original, my lord, let us see. As the client, according to my instruction. No date. Let us see the original one.
This undertaking is being taken as per the rules.
Yes, my lord. Yes, my lord.
Rule is not quoted.
As per the direction of
No. This undertaking is taken under what provision? Hello, we'll fix it. You get the records of these petitioners along with the undertakings in originals. Okay. Out, Mr. B.D. Das, the learned senior counsel, assisted by Mr. S.C. Cross. You are with him?
Yes, ma'am.
Assisted by Mr. S.P. Cross, as well as the other counsels appearing on behalf of the petitioner, and Ms. P. Sharma, Mr. A.K. Thakur, Mr. S.S. Roy. You are also there, Mr. You are for?
Comptroller and Auditor General.
For the central government standing for the central government, and Mr. Akita Lukde appears for the comptroller and auditor general. Upon hearing the matter, this court deems it proper that the respondents should produce the undertakings so submitted by the petitioners in the respective petitions. In original. On the next day. Is the matter on when can you get it?
after 2 weeks,
We'll have it on 15th.
15th of May.
It's the matter again on 15th of May 2023 for further. Anything urgent? Urgent only, yeah.
Item number 46, my lord. For pensionary benefit, my lord, husband died, my lord, they applied for next in certificate. Because, my lord, that there was earlier a court case, my lord, 125 proceeding is running, my lord. With that time, my lord, husband died, he was a school teacher. And on account of that or any other reason, my lord, that is not some circle officer, my lord, not issued next to kin certificate as such, my lord, that the authority could not process the pension paper.
Yes, Lord. I have placed the instruction, Lord.
So tell me, what is the business of asking for the next of kin certificate? The fact that the petitioner is the wife,
Yes, Lord.
and the right is much more. If it is a case of family pension, then the sister.
This document is the vital document because Lordship, who else are there after the date of the deceased? Even in this case, particularly, Lordship, the page 16 in the death certificate, her name is not recorded. So that
You
is
are
a
not in
problem.
good terms. You are divorced.
Not, madam, only application file 125 proceeding, my lord, for seeking compensation, and that a replied filed by the husband admitted that he is wife, my lord. And only said that because of some house loan or something and
But
another.
is this case pertaining to next of kin certificate?
Yes, my lord, that
No, is it the case of pension or next of
no,
kin?
both prayer is there because when next kin certificate is not issued by the district this deputy commissioner, that's why pension paper would not process, my lord. That's why, my lord.
Are those matters both not different? Then why are you filing one with petition? One is a bench four matter.
Once, my lord, the next kin certificate is issued, my lord, the process will run. Now, additional prayer I made, my lord, that thereafter, my lord, the government will process according to law. That much prayer is respondent will process according to law. That much prayer was made, my lord. That 58, my lord, page 57, my lord, the Gaura certificate, it's very much clear that he is the wife.
But that is from another gown, not from the
No,
husband's
my lord,
gown.
from that.
No, you have not given it from the husband's gown.
No, my lord, that Atikampur Gambel, where the husband reside, my lord, that same village, my lord.
She has applied twice. Earlier, that case was rejected. Now, she has submitted the certificate of the ground pradhan of the deceased husband.
Now you have done
No rejection order, my lord. Now I have heard, my lord, no communication was made, my lord.
But Lordship, only that that Gambura certificate will not suffice, Lordship, because petitioner has to show the relationship with her husband.
Married how?
Married, my lord, according to Hindu rights, my lord, that was not disputed by the husband, my lord, during proceeding, my lord. That is not disputed at all.
No, you married how? How did you marry? Only
According to
only
Hindu rights, my
traditional.
lord. According to Hindu rights.
No registration.
No registration. My lord. According to Hindu rights, my lord, social marriage was night.
And our office accepts the voter ID card, Aadhaar card.
In the voter ID card, Aadhaar card.
My lord, voter ID card, my lord, that marriage was solemnized in 2017, my lord, that prior to his father's house, my lord, that all the documents there after marriage, my lord.
What was the age? What was the age of the husband when he died?
Husband age was, my lord.
Did he die in harness?
Die in harness, my lord. 900.
This is a case of compassionate family pension.
Yes, my lord.
Is it a case of compassionate family pension?
It's a family pension, my lord. From my lord 2017.
When did he die?
It died on, my lord, 11/8/2001, my lord. Recently, my lord.
2000?
2021, my lord.
And what was his date of retirement?
Date of retirement, my lord. His husband date has husband age was, my lord. Husband age was, my lord. In his written statement, he specifically stated, my lord.
Mr. Sharma, you are not prepared.
And at
You want this
52, my lord,
court, you
58.
insist the matter to be taken as urgent. First of all, this is not an urgent matter. This matter can very well, you don't know what is which year your husband is going to retire.
And 52, my lord, the last year he was at 52 years, my lord. That after 8 years, my lord, then
He
now
died in 2021
21, my lord.
and he was 52 years
Yes, my lord.
at that point of time.
Yes, my lord.
Or is it on the basis of the written statement you are saying?
Written statement, I am
So
saying.
written statement, did he die on the date of filing the written statement?
Thereafter, my lord.
When did he die?
And my lord died on 11, my lord. The death certificate is there, my lord.
And when did he file the written statement?
Written statement was filed on, my lord. 24, my lord. 24/9.
You don't know.
Written statement was
Okay,
filed on.
it's the matter of the 4 weeks.
Yes,
I gave you an opportunity, you didn't take
my
it.
lord. Next.
After 4 weeks.
Lordship, that instruction will be.
No, you take it.
indirect.
Well, he is not helping this court. How can this court help him? You don't know what is the thing. Yes, anything.
My lord, item number 43, my lord, the date may be fixed, my lord.
Why?
My lord, in this matter, my lord, the opposite counsel has to file the affidavit, matter.
So very good. You'll be happy. Respondents, they don't file affidavits.